এই মোৰ বেগত টেবলেট এটা আছে, ওলাই থব, এতিয়া নালাগে, এতিয়া নালাগে।
Item number 1.
May I please,
Yes.
my lord. My lord, the petitioners herein are aggrieved by cancellation of the selection process, my lord. Conducted for appointment of two posts of finance and account officer under the Department of Finance, my lord. My lord, what happened, my lord? In the year 2021, my lord, an advertisement was issued for filling up of two posts of finance and account officer, my lord. My lord filed the advertisement in phase number 30, my lord. Phase 30, my lord.
You submitted your candidature.
Yes, I submitted my candidature.
The
My lord,
process progress to what extent?
my lord, the preliminary exam was conducted, and I have been, my lord, qualified to appear in the mains exam, my lord.
Means consist of interview or written?
Written, my lord.
Written.
Written, my lord.
Okay. What is the scheme of examination?
My lord, phase 30, my lord.
Phase 30.
Phase 30 is that, right?
Preliminary main. Okay. Followed by interview.
Followed by interview.
So you crossed the first hurdle.
First hurdle, my lord. Preliminary examination.
Then
My lord, in this case, my lord, altogether, my lord, there is only two posts, my lord. Altogether, my lord, 2097, my lord, aspirants have, my lord, participated in this exam. And out of that, my lord, only 24 has been qualified for the mains exam, my lord.
how many petitioners here?
There are nine, sorry.
9.
9 in number, my lord. My lord, thereafter, my lord, what happened, my lord? In the year 2021, my lord, there was some allegation, my lord, in related to the exam of assistant engineer civil examination conducted by the public service commission, my lord. There is leakage of paper, my lord, allegation of leakage of paper, my lord. After what happened, my lord, some inquiry has been done, my lord. And after inquiry, my lord, some of the exams conducted in this intervening periods, my lord, that has been cancelled, my lord. But this exam, my lord, pertaining to this exam, it was not cancelled, my lord. It was kept in abeyance, my lord. Thereafter, what happened, my lord? The petitioner are under legitimate expectation that once this, my lord, fiasco is over, their main exam will be conducted in due course of time. But what happened, my lord? Ultimately, my lord, by this impugned notification, which is 8,
Page
58, my lord.
58. Yes.
Page 58, my lord. My lord, our exam has been cancelled, my lord. Serial number 1 is our exam, my lord. Finance and accounts officer, my lord. My lord, this was cancelled. My lord, this,
What is the 21st April 2025?
that is at page, my lord, 73.
Page
73.
73.
Yes, ma'am. 62, no, not 62. 62, it is also in the 62, my lord.
73. Exercise of power.
My lord would find this, 62 also.
Election 9.
Hmm?
Election 9, 60.
62.
Space 62, my lord.
62. 2.
Yes, my lord. My lord, the
21st April
21st April 2025, my lord.
62.
Yes, my lord.
For the same notification.
Page 62, my lord. Yes, my lord.
Conveyed by the provider to issued right sides and the Okay, validity of this particular notification is to be examined, I think,
Yes, my lord.
because this is a consequential one, 16 October.
Yes, my lord. This is a consequence of
A
this
solicitation
notification.
appears to have been taken for one-time relaxation of age.
My lord. My lord,
Why before division bench?
my lord, since this is an notification under Article 309, my lord, rules, my lord,
Okay.
that's why my lord, this is what-
Will you should notice at least?
Okay.
Will you should notice? Yes, that
Notice.
heard Mr.
H. Lampu, my lord.
Learned Counsel for the petitioners. And Mr. Spencer, learned. A government advocate,
Senior government.
1, 2, and 4.
1, 2, and 4. Who is for Public Service
Lordship,
Commission?
I'm representing
Mr.
R3.
Spencer, Learned Standing Counsel. APPSC, full stop. On 25/3/2021, comma, APPSC published an advertisement inviting applications from eligible candidates to fill up two posts of Finance and Accounts Officer, stroke Treasury Officer, Group quote unquote A gazetted within bracket Department of Finance, full stop. As per the advertisement, comma, the process of selection consisted of a preliminary object examination, comma, followed by and main examination followed by interview stroke viva voce, full stop. In the portion to the advertisement, comma, a total of 2097 candidates submitted their candidatures and appeared in the interview, preliminary examination, full stop. After the preliminary examination, comma, 24 number of candidates were qualified to appear in the main examination, full stop. The petitioners, comma, 9 in number, comma, were among those 24 candidates, full stop. When it is submitted by the Learned Counsel for the petitioners that in the year 2021, comma, another process of selection initiated for filling up post of assistant
Engineers.
engineer
Civil.
in
My lord, this is my lord, combined, my lord, combined exam.
different government departments who were cancelled, finding illegalities to irregularities in the process of selection. Post of pursuant to that, comma, the process of selection initiated for finance to post of Finance and Accounts Officer, stroke Treasury Officer, were kept in abeyance. Post of subsequently on 21/4/2025, comma, the Department of Administrative Reforms and Training, Government of Arunachal Pradesh, published a notification in exercise of the powers conferred by the proviso to Article 309 of the Constitution to relax prescribed age limit for direct recruitment with a further decision that the previous vacancy notifications issued prior to 2024 and as mentioned therein would be cancelled by the APPSC subject to the conditions mentioned therein. Full stop. It was in consequence to the notification dated 21/4/2025, comma, in notification dated 16/10/2025 has been published by the APPSC, whereby the selection process initiated for Finance and Accounts Officer has been cancelled full stop. Alleging a violation, alleging infringement of their legitimate expectation and comma, the petitioners are before this court by the instant repetition, stating that they have a common cause of action, full stop. Matter of refer consideration, issue notice, returnable in 4 weeks. As so and so appeared, accepted notice on behalf of so and so. Issuance of formal notice stands dispense with extra copies within 2 working days from today.
My lord, there is interim prayer, my lord.
Interim prayer at this stage is not possible. The prayer for interim relief is kept open for consideration on the returnable date.
My lord, since my lord, press
No initial
notification,
process has been initiated, no fresh process.
yes, my lord, press advertisement what was not.
As soon as it is published, you come.
My lord, it will be, my lord, hardship for the petitioners, my lord.
Hmm?
Till then, my lord, till returnable date, my lord.
No,
Faculty,
no,
my
no.
lord. Till
At this
returnable-
stage, no.
till-
Let fresh advertisement comes then.
Obliged.
Item number 2.
May I please, madam? Madam, on the
Yes.
last occasion, madam, the respondent number 2, the has prayed for my filing of affidavit, madam.
Respondent number 2,
2, madam.
Regional Director, Staff Selection Commission,
Madam.
is represented by whom?
Malad, I'm,
Yes.
Malad, as per the instruction received from the Malad, respondent, Malad, I'm, Malad, instructed to file affidavit, Malad. There is some certain defects in the affidavit, Malad. So at this stage, Malad, may I pray that Malad, some more time may be granted so that Malad can be bring on record, Malad.
How much time?
3 weeks time may be granted.
Yes, Mr. Chandra, you are the repetitioner.
No, my lord.
No, I am the
Oh,
representative.
you are the repetitioner. Okay,
They are
okay.
the
It has come from
tribunal,
cat.
cat, my lord.
Madam.
There you are the petition.
My lord. There, the judgment, case of notice of
Continue to-
termination was set aside and original application was allowed.
Okay.
In the similar facts and circumstances, your lordship, on the same ground, another employee of Nagaland, Sujit Kumar, his case also allowed, but Comptroller and Auditor General did not prefer any appeal.
We'll come to that later on, similar cases. We'll taste that.
And their judgment I have
Let the
enclosed in the
pleadings be
affidavit in opposition, my lord.
Let the pleadings be complete. Any interim order operating?
Yes, madam.
Oh,
Interim order.
then you should file immediately.
Interim
All
order.
right, Mr. R.
Okay,
Shakil, Learned
Huh?
Counsel for the
Okay.
petitioners.
No, no interim order.
Mr. M. Chandra, Learned Counsel for the respondent number, and Mr. So Learned Counsel for the respondent number 2. First of, Mr. Sorensen, Learned Counsel appearing for the respondent number 2 has submitted that he has received an necessary instruction to file counter affidavit on behalf of the respondent number 2.
Correct.
And has short for further 3 weeks' time to file the counter affidavit. Full stop.
My lord, can it come after 4 weeks, my lord?
4 weeks.
After 4 weeks.
Okay, 4 weeks. Short by counsel for the respondent number 1, come and list the case after 4 weeks. Oh, it is, okay, the interim order passed earlier. If any, shall continue till the next.
Obliged.
Deputy.
Anything?
Obliged, your lordship.
Item number 3.
Malad, here I am for the appellant.
Hmm.
May I please, your lordship. Lordship, I am agree by the Malad, honorable single bench order, Malad. Lordship will find at annexure Malad, the impugned judgment in order, second, in
Age,
page number, Malad, 600,
oh, it is
Nine.
for first time.
Malad. Malad, what event, Malad, the respondent.
Page,
Page number, my lord, 609, annexure 6, my lord. 609, it
609.
starts from, my lord.
Okay. Yes.
My lord, brief fact of the case is, my lord, the respondent authority issued an IT, my lord, tender, e-tender, my lord, 2-bid system. And accordingly, my lord, we purchased, my lord, bid documents. And being qualified, my lord, eligible, my lord, about to, my lord, purchase, my lord, participate in the tender process, my lord. In the meantime, what happened, my lord, the tendering authority, who is the executive, my lord, the engineer, he remained absent from the, my lord, office of the executive engineer, my lord, on sightings that he was busy in some other work, my lord. So thereby, my lord, we have been prevented from participating in the tender, my lord. Our documents has not at all been, my lord, received by the, my lord, tendering authority. That, my lord, in such situation, my lord, tender, my lord, documents some documents in original has to be produced first, my lord. Then after it will be processed, my lord.
What is the tender? NIT?
NIT, my lord, lordship will find at
It is e-tendering. Page 58.
correct, my lord. Page 58, my lord.
ऐसा है हाँ हाँ हाँ
Page 58,
this is मिल गया 58 yes
just for a moment, my lord, may I take your lordships too,
double beat
my lord.
online tender
Correct, my lord.
e-tenderings
My lord, that if lordship peruse, my lord, serial number 1, it is, my lord, availability of tender online for bidders.
Hmm.
It starts from 30th, my lord. Notice was issued on 30th June 2025 itself, my lord. It starts from 30th June 2026 to 14/7 July, my lord, 2025. And my lord, the start in.
so within that period this can be downloaded
Yes, my lord.
tender can be downloaded
My lord, this has to be, my lord, again, my lord, clarified by close. My lord, the opening that is, my lord, may kindly note the date and time of the opening of bid, my lord,
Huh.
is on 15/7/2025, my lord. 10:30 hours, my lord.
yes
My lord, serial number, my lord, I'll skip rest, the close. Close 5, my lord. Married, my lord. The bid can be deposited documents non-refundable in case of arrest 10,000 along with the EMD and other original documents, my lord. Other original documents to the Executive Engineer Yamsa Division AP from 30th June 2025 to 5th July, my lord, kindly know, 5th July 2025 during office hour at the specified opening place for the work listed in the tender, my lord. My lord, whereas, my lord, last date of submission is on 50, my lord, 14/7/2025, my lord. But this original document has to be, my lord, first produced before the executive engineer on or before, my lord, 5th July 2025, my lord. Meaning thereby it is a 5 days delay, my lord, the 5 days tender, my lord. Original documents, other required documents has to be
what is the
produced.
meaning then if you have to submit it physically
Correct, my lord. Now, my lord, physically, my lord, despite this shortest period,
if it is e-tendering
e-tendering, my lord. Original, my lord, it has to be uploaded as well as some original documents has to be first produced for, my lord, the verification, my lord. My lord, what happened, despite this shortest period, my lord, we tried our best to, my lord, submit the original documents and we went to the office of the, my lord, the executive engineer for submission of all these required documents, my lord, on time, my lord. My lord, may kindly appreciate one thing, my lord, my original documents and other things, it is page number, my lord, 80, my lord. This is the one important documents in the tender process, my lord. EMD has to be, my lord, submitted along with all required documents, my lord. This is the only photocopy, my lord. Original, still I'm.
what
in
is
possession.
page 80
Page 80 is the,
What
my
is
lord, one
this?
of the, my lord, the important documents, my lord. This is EMD, my lord.
you prepared it on which date
it is prepared on, Lordship will find at, my lord, prepared date is. Oh, no. It is much
27. 27.
correct, my lord. 237. My lord, the amount is also mentioned 39 lakhs 70,000, my lord. Yes, 27, my lord.
Hmm.
And my lord, when I went to the office of the, my lord, the executive engineer to submit all these documents, my lord, unfortunately, my lord, he remained absent from entire period, my lord, for which I had to lodge an even FIR that executive engineer who is the responsible for this tender is, my lord, not available and found missing, my lord. So therefore, FIR has also been lodged before the concerned police station, my lord. And the officer, my lord, on that day, my lord, 2 officers were deputed for receiving these documents. My lord, 2 officers has categorically mentioned, given testimony before the, my lord, before the petitioner and others that the executive engineer is not, my lord, available. He's not in the office for which the, my lord, the original documents has not been produced, my lord. My lord, my lord, may kindly peruse the depositional, my lord, statement, my lord, testimony given by the, my lord, the 2 junior engineer who were, my lord, the deputed for this particular work. Lordship will find at page number 90, my lord, 93, my lord, type copy. '93, my lord. Married, my lord. With the understanding, had been assigned the work of receiving processing fee and the earliest money deposit from the tender bidding for the upgradation of so and so work, so and so duly after application, after the application and tender documents have been verified by the executive engineer, Yamsa engineer PWD Yamsa division. But due to, my lord, absence of the concerned authority, the person assigned for, my lord, receiving and forwarding the application could not be provided us with the said application, and that is why we unable to receive the processing fee and the EMD from the so and so. My lord, this is
Hmm?
my firm.
Assign the task of receiving processing fee and earn EMD
Correct, my lord.
or from the tender bidding.
Other
for
other
the
documents
work
also, my lord, it has been
so
specifically
and
not
so
mentioned. Other
duly
things.
after the application. Tender documents have been verified by the engineer. But
My lord, what?
no,
What-
they were assigned for the work of receiving processing fee and earn EMD.
Correct, my lord. That will be done on, that will be, my lord, process further on the approval of the executive engineer, who is the tendering authority, my lord.
Yes, they were assigned to receive processing fee and EMD.
But that has not been processed, my lord.
No, why they did not receive it?
As because, my lord, the executive engineer, as they said, the executive engineer, who is the head of the authority, my lord, this tendering authority, he remained absent in the office, my lord.
No, receipt of processing fee. Processing fee is 10,000 in
Correct, my lord.
cash and EMD.
EMD and other
EMD
documents.
in the form of say banker check, whatever,
Correct, my lord.
DD, etc.
Correct, my lord.
Or
Yes, ma'am.
so they were assigned for receiving processing fee and EMD
Yes, my lord.
from the tender bidding for the work so and so,
Correct, my lord.
right?
But, my lord, that
And that is the first point, that whether 10,000 is given or not, and EMD given or not. Thereafter, they will look into the tender document.
correct, my lord. They have not received, my
Tender document will not be examined prior to deposit of 10,000 and EMD.
my lord, may kindly appreciate one thing that has not been received in original, my lord. Original has to be received first, my lord. Then after that will be verified. Then after that will be processed.
Huh.
Then after it will be qualified for the technical bid, my lord. But my lord, my precise case is not at all the executive engineer, who is the tendering authority, has not received my other original documents which I supposed to, my lord, the
No,
submit
these are statements before whom?
before the, my lord, before me, my lord.
Huh?
But-
Before you? Why this?
When I before, my lord, when I went to the office of,
are under obligation to give you such
my lord,
statement.
when the authority is not available, my lord, it is, my lord, I insisted them to give such, at least so that, my lord, some documentation has to be given, my lord. That is the only, my lord, the way and procedure, my lord. Otherwise, if he refused to, my lord, even issue this letter also, I'll be nowhere, my lord. So therefore, at least this document shows that, yes, we went to the office of the executive engineer, but then executive engineer remained absent, for which the processing fees and other things has not been processed further for the technical bid, madam. That is the precise my case, madam. And my lord, again, lordship may peruse another statement, page number 95, my lord, by which it is more clear, madam. Two officers whom the work has been assigned to receive, my lord, the original documents, they given a statement that because of the absence on the part of the executive engineer, the tender documents, my documents has not been processed further, madam. That is the precise case, madam. I understand, being an MP of the PWD Yamcha division, was assigned the duty of the receiving the applications from the tender bidders for the work so and so, with effect from 30th June 2025 to 5th July 2025. On dated 3rd July 2025, I have received applications from Sri MS Badri Rai, me, the petitioner, so and so. And on 4th so and so, I have received the applications from so and so construction company, so and so. And
Did he give any acknowledgement?
yes, madam. This is
He
kind of
said that I received.
this is kind of acknowledgement given by the executive, junior engineer, two junior engineers, madam. Madam, last portion is important, madam. Married, madam. Last portion of the page 95, madam.
95.
I have forwarded.
Where is the original?
Original is with me.
Huh?
Original is with me, ma'am.
Because for 93, page 93 undertaking, you have annexed the originals. Photocopy of the original.
Original, madam.
But
Photocopy of-
for this 95, you have not annexed.
madam, it is 94, madam.
Huh?
94, madam.
It is 94.
And 92 is the original, and the type copy is 93.
Moku Yamsa. Okay.
And 94 is the original
Moku
in handwriting. Type copy is 95, madam. I am on 95, madam. Page 95, madam.
What is this process? I don't know. What kind of process? Huh? But as per the NIT,
Madam. Madam, may I just complete by reading this page 95, madam, last portion, madam, which is very important, madam, to me, madam. At least, madam, which, madam, everything is clear, madam. I have forwarded the said documents to EEPWD Yamcha division for verifying the bidder's document for further pursuit. But he was unavailable at division office during office hours from 3rd July 2025 to 5th July 2025 due to reason not known to me, madam. This has been given by the two engineers, junior engineers, madam. Muttu Yamcha, JE Yamcha division, and Jumken Karbak, the JE Yamcha division, madam. The officers whom the work was assigned, they given a statement that my executive engineer, who is the tendering authority, remained absent from the office, for which the tender documents was not processed further, madam.
where is the need for tender document processing? For what? What reason? Because online submission is on a later date, from 1/7 to 14/7.
Correct, madam.
Right.
Yes, madam.
What is the need for processing? Let us have this again. Clause 5.
That is the hardship,
Huh?
that is the hardship which they wanted to ask the intended tenderers, just to award the work to the
Yes,
chosen
because it's-
bidders. This hardship condition has been incorporated in clause 5, madam. This is the intention of the authority whom to award the work. They have already chosen, my lord, by reading this particular clause, my lord. Whereas last date of submission is 14 July, but my lord, this has been again shortened to 5th July, by which, my lord, every document has to be submitted first, my lord. Otherwise, documentation, my lord, needs more days, my lord. It requires, my lord, the number of days for preparation of documents, my lord. Then after it will be uploaded, my lord. But then condition is original document has to be submitted on or before the 5th July
Did you
2025.
submit online bid?
Online bid, my lord.
Did you submit?
No, my lord. Unless it is verified, unless it is not processed, my lord, we cannot.
Where is the bar?
My lord, bar is as per this, my lord, closed.
The portal will not be open for you.
My lord, it will be often, my lord, but again, that will be, my lord, portal process unless it is not processed past further, my lord. Clause 5 is, my lord, is the hardship, my lord, inserted by them. My lord, as per the, my lord, the catena of decision, my lord, I cannot challenge this clause. This is the hardship, my lord, which they wanted to, my lord, the reject or, my lord, eliminate those unwanted tenderers, my lord.
What has happened thereafter?
Thereafter, my lord, we went to the office of the, my lord, the executive engineer time and again, having no option, my lord, we made a representation before the, my lord, the executive engineer, my lord, executive engineer as well as, my lord, the chief engineer, who is the, my lord, the controlling authority of the, my lord, this division, my lord. My lord, just we made a representation before them, my lord, the chief engineer, superintending engineer, and superintending engineer, my lord, page number 103, my lord. This is our representation 103, my lord. Addressed to the, my lord, superintending engineer, my lord.
Hmm.
Pursuant to this representation, my lord, what the superintendent engineer have done is, my lord, he, my lord, extended the, my lord, the last date of submission by issuing corrigenda, my lord.
What is that?
Even that has not been taken into consideration by the executive engineer. My lord, page number 96, my lord. Corrigendum issued by the, my lord, the superintending engineer, who is the, my lord, controlling authority of the, at least executive engineer, my lord. Type copy is, my lord, next page, my lord, page 94, my lord. 96 is illegible, my lord, original, but type copy is page number 97, my lord. Name of the work given, my lord, corrigendum of the notice inviting tender, my lord. The following corrigendum is being issued to the above NIT documents and to be read as follows, my lord. Pre-document serial number 1, pre-bid start, date and time, my lord, 10 July 2025, my lord. And the pre-bid date end, bid end, date and time, my lord, 10th same, my lord. Now, my lord, serial number 3, the physical submission of EMD, tender fees, and necessary documents. My lord, this has been
So
extended.
this has been extended.
Correct, my lord. But that has not been taken into consideration. My lord, having no option again, my lord, we made a representation, my lord, filed an FIR before the, my lord, the concerned police station, my lord. Concerned police station even, my lord, having no option, my lord, even issued notice to the executive engineer where you are during this period. And it is a matter of concern for the entire, my lord, department. At that relevant point of time, executive engineer not at all remained present in the office. My lord, such crucial stage in the such tender process. One hand you are preventing me, other hand you are.
So he was the only person to process the application, verify the
My lord, as
application.
per the record, my lord, 2 persons were, my lord, debarred from participating in the tender process, my lord. As per
No, no.
this record, my lord.
Executive engineer is the only person who is the authority to scrutinize the
Correct, my lord.
bid document.
Yes, ma'am. He has to process, he has to verify, he has to, my lord, initiate everything. Then after, my lord, it will be go for the, my lord, the technical bid, my lord. Then after financial bid, my lord. Since it is two bid system, my lord.
What happened thereafter?
Thereafter, my lord,
What is the stand of the government?
government, my lord, they are saying that, no, you are not at all, my lord, fulfill the terms and conditions as stipulated under one of the, my lord, the condition of the contract. And my lord, my bid was rejected on 3rd July 2025, before the expiry of the, my lord,
Where
last
is
date
that?
of submission.
Where is that?
My lord, they have filed in the statement, my lord, rejection order, my lord. And irony is, my lord,
Where is that? Where is that?
in their affidavit, my lord,
Page.
Mm, 146.
I see.
Page number 146, my lord. 146 communication. 146.
146.
जरा जूनियर पेजिंग भी शिफ्ट करो पूरा सिंक्रोनाइज नहीं है एक यहाँ पे कुछ नहीं
Simply, they are saying that, my lord, I have not fulfilled the terms and conditions as
Time of
stipulated.
submission of collection.
And my respectful submission on this issue is, my lord,
Where is the section 3 conditions of contract? Under additional special conditions.
पेज में कितना असेल है 130
136 is the relevant page only.
yes
136.
136 plot 26
my lord, admittedly, we have not enclosed the entire.
136.
Otherwise, the bid document is at 406, the whole bunch.
406.
Yes, whole bunch.
Which condition is violated?
26.
26 my lord 136
26. Processing fee shall be collected
Yes, my lord.
from the division. What is the meaning? Processing fee shall be collected?
Division office.
What is the meaning? The processing
Yes,
fee
for the purpose.
shall be collected.
Yes.
That I have not understood. Processing fee shall be submitted.
Should be deposited actually. Yes.
So this is not vague.
No, but the other things are clear, my lord.
Processing fee shall be collected from the division office, PWD, OMSHA, from the assigned person. What collection?
Processing fee has to be
Receipt,
deposited by.
It has to be deposited.
Yes, my lord.
it means my lord they have a deposit and they have to collect the receipt my lord after deposition they have to collect the receipt the proof my lord that they have deposited the processing fees my lord that exactly means my lord
Kindly see for. On production of bidders' original identity proof, PAN card, Aadhaar card, contract registration certificates. On such and such, failing which no processing fee will be received or processing fee received, no in order shall be summarily rejected. The documents were not furnished original, that's all. So Lordship peruges the judgment from page 620 onwards, it will be clear.
Now, my lord, when my everything is refused to accept, the way the question of my lord, non-furnishing of the documents, my lord.
Where is that rejection?
Rejection, my lord,
Again, once again.
page, my lord, 146, my lord. And one, my lord, the one thing is again, my lord, it is clear from these documents that his junior engineer, he is saying that the executive engineer is not remain in the office of the executive
The
engineer
time of
himself.
submission of
And my lord, these documents
collection
has
of the
been,
processing fee, it was observed that the requirements stipulated under section 3. Section 3.
correct.
Which is section 3?
Section 3 of the, my lord,
Comes under, those conditions comes under section 3.
Section 3 might be a first one.
Yes.
Might be a first one.
yes, my lord.
What is the indication?
Your Lordship.
Specific region?
They are not disputing, they are accepting that fact.
Which one?
It starts from 406, the whole document.
You could have said up to 5/7/2025, notwithstanding superintending engineer's extension of date till 10/7, right? That you have not deposited this So why don't you deposit this till last date?
Yes.
And there should be specific that this document you have not submitted.
They were-
It appears to be something more than meets the eye.
If your lordship sees the registrar, that has been kept, at 148
Let us see first section 3,
section.
additional. This clause 5, I am saying, it is a strange clause for me.
Malad, in
So far, I don't think it is in conformity with GFR 2017
correct.
or any other document. Where is that clause, section 3?
Yes.
Notification.
Additional? What is the name? Additional conditions of contracts under additional special conditions. Additional special conditions. Special conditions. Additional conditions. Additional special conditions.
Section 3.
What?
471. There are 29 clauses. Which one is?
26.
No, there are 29 clauses.
What?
There are sea of clauses,
Yes.
right? Which one is?
But in the NIT.
Which is not indicated.
Yes.
He had the option
my lord,
of meeting the deficiency
Correct.
up to 5/7/2025. Huh.
at,
I have seen, but there are 29 clauses.
yes.
Where is that in that letter? He has become proactive.
My lord, they were.
146.
Kindly see, they were aware of what is required to be submitted, your lordship.
No.
148. Kindly, 148. It is not that they were not aware of that, and it is not their case. Their case is.
Where is the 148? What does it say?
This is the register that has been kept by receiving the original documents. My lord will have 149. That's right copy.
Let us see.
Registration, PAN card and Aadhaar card not submitted and original documents mentioned above has not been produced.
So is it not your duty? It has to be, the competition has to be bigger.
Yes.
That is the main motto,
Absolutely right.
right? Then, if he has not submitted some document, you are saying that the bidder failing the above condition of approved uploaded NIT may be treated as non-responsive. Is it not your duty to indicate specifically that this is the deficiency?
Yes, my lord.
Because he had the timeline up to 5th of July as well as up to 10th of July.
And my lord will appreciate, my lord, they did submitted it on second and there were 8 days left and did not do it, my lord.
This comment at page 148.
My lord, he's a businessman, my lord, he's a contractor.
Yes, I know. It is not that I do not know anything about tender jurisprudence.
Yes.
Right? But this document is your document, internal document, 148.
148.
Is it not your duty to indicate?
My lord, this was indicated, my lord.
Where? Where is clause 26?
Those- It may not have been written here, my lord.
Oh, where proper he gets it?
My lord, will kindly appreciate also that it is not his case, my lord. His case is that the executive engineer was not there and his documents were not accepted. That is his,
No, this is your stand.
yes,
Page 146 is your stand.
yes. And 148 is the record.
146, is it communicated?
Yes, it was communicated.
Communicated.
My lord, we have not received categorically. We have made a statement in our affidavit. My lord, we have not.
Where is the evidence this has been done? 146.
Communication, my lord, 146, my lord. That is the communication, my lord. 146.
Where is the received communication? Merely tick marking is will not do.
My lord, this question they never raised before the single bench, my lord, that they have not received. What, my lord, they were saying, my lord, the executive engineer was missing from the office and his tender was not accepted. When, my lord, this
Rejoin that one.
documents are scrutinized by the largest single judge, then found that his document was processed. But the reason for the rejection is he has could not produce the original document. This is the only ground, my lord.
Okay, get the
Wrong, my
records,
lord.
get the records, we'll see.
Yes, my lord, we can get that report. my
Yes.
lord. No issue.
Can get the record. We'll examine. Whether this has been communicated or not.
My lord,
Records are produced on the last.
नहीं, for this नहीं किया.
yes,
नहीं किया. Call किया था.
yeah.
देखिए, डस्टबिन में देखिए नहीं तो.
You will need reply करना.
हम तो रिकॉर्ड के लिए मांगे सर, रिकॉर्ड मांगा नहीं.
There is something more than meets the eye.
My lord, may 1 second, my lord, kindly peruse my lord, 148, my lord. My lord, this could be precise, my lord, whether he on that day, my lord.
This is your internal document, sir.
My lord, these are the records.
This
my lord.
document is internal document. If 3/7
My lord, this
is the date,
my lord.
is the date, right? One of the principle of tender jurisprudence is that there should be more participation.
4%.
Right, on 3/7,
My lord,
when the date of submission of physical bid also, according to your version,
my lord,
5/7, later on extended to 10/7.
my lord.
Was it not your duty that these are the deficiencies? You please meet or will, your bid will be declared responsive. But he on 3/7, by this letter,
But-
he has said it will be declared non-responsive because conditions are not fulfilled. Additional, what is it? Additional special conditions. Section 3, which has 29 clauses.
My lord.
Which one will?
My lord, let us for a moment, my lord, assume it, my lord, yes, there is a mistake communicated by the department. My lord, now, my lord, after that communication. as
This,
contract-
whether he mentioned in his writ petition, this 3/7,
My lord,
whether he mentioned in this writ petition about the 3/7/2025 letter?
37.
No, my lord, not
No.
at all.
And your affidavit in reply?
The moment they filed, my lord,
I'm sorry, my lord, they never disputed, my
my
lord.
lord,
Let us have
my lord,
your affidavit
the
in reply.
moment they, my lord, filed an additional.
Let
my
us
lord,
have your affidavit in
Yes,
reply.
madam. In additional, my lord, affidavit in reply, we categorically denied that statement, madam.
That they have.
That's it.
That they have.
We denied, madam.
They have denied.
In writ petition, we, my lord,
Where?
Contract. 5 में था ना.
No, I'm okay with it, I'm okay with it.
Which paragraph?
Para 6, my lord. Page number, my lord, this starts from 584.
Paragraph 6.
Affidavit in opposition, affidavit in reply to the affidavit in opposition filed by the respondent number 5, my lord.
Paragraph 6. No, 3/7 is not there. There is no denial of 3/7 in para 6.
Executive engineer, my lord, in fact, 2, 3 affidavit in reply were filed.
Huh? I have read page 587, 586.
Just.
If he had received it on 3/7, there is no point submitting him representation on 4/7/57. If really it has been served, the notice should have been that you are having these deficiencies. You meet these deficiencies, or your bid will be declared non-responsive.
Representations are to the effect that the executive engineer is not present. That's.
It is judgment. Let us.
Representation का है representation को the representation आपका कौन है ना एक से नया है ना चलो देखो ले representation petition rejoinder petition copy 106
Perusal of the above clauses, notice of fees shall be collected. A division office on the assigned person.
It is their own admission that the EMD and all are prepared. But executive engineer remains absent. That is their.
Which one?
Page
See,
81.
because we are wanting if he is not sincere, you not have prepared the EMD for 39 lakhs or this document.
Yes.
If he is not sincere to submit the bid, he would not have prepared this bid security or EMD, whatever,
My lord,
on 2/7/2027 at page 80.
yes, yes. See.
Right.
Yeah.
This is for an amount of 39 lakh
Yes.
70,000.
Yes.
Then he would not, is it impossible to believe that he would not deposit processing fees of rupees
My-
10,000?
my lord
Then, secondly, thirdly, whatever he had deposited, you have to accept. Where is the question of scrutiny? Where is the, no, bid document. You reject it after 15/7.
That's what, my lord. The bid was.
Why putting the cart before the horse?
No, my lord. The document that is submitted, all these documents, it was processed, my lord. It was.
If he has given a photocopy, wrong document, whatever,
Yes. That was done, my lord.
basically the essence is online bid.
Yes.
After online bid, it will be verified, examined,
Exactly, ma'am.
right? No, you are examining that all documents are given or not.
The requirement as per. clause
I'm sorry,
26
not all documents, very specific mentioned in the clause 26, my lord. What are the documents, my lord,
Let
originally has
us
to produce,
again,
my lord?
let us again,
Ye lordship may kindly.
let us again, clause 26, page
Page, my lord, 136, my lord.
136.
Yes, my lord. These are the only document he has to produce original, my lord, not all NIT documents, my lord. Because it was a two-bit system, my lord. Original identity, my lord, proof, PAN card, Aadhaar card, then contract registration certificate on or on 36/2/5/7.
Okay, PAN card, I understand. Whether a legal entity, this is a company, I think, has a Aadhaar card.
Badri Rai,
No, that is in respect of the person who comes.
my lord,
Authorized representative.
authorized person.
On production of bidders original identity proof. The PAN card, Aadhaar card, and contract registration certificate.
It would be the
If it is a bidder is a legal entity. le-
no, my lord.
No, the first, no, my question, I don't know. No.
The company-
Whether if the company is the bidder, then whether authorized representative must have contract registration number.
In respect of a firm, he will.
No, on contract registration number. Each word has significance. Whether if the company is a contractor, class 1, who else can have contract registration number other than the company?
Yes, my lord.
Who can? Contract registration number, please. Meaning of it.
That will be the registration number, my lord,
Huh?
which was registered, the firm.
The farm.
Farm, yes, my lord. Not the proprietor.
Bidder is, my lord, participating, my lord. Somebody.
Bidder is a company here, sir. Mr. Is it a company or proprietor?
It's a company, my lord.
Company.
Company.
Where is your registration certificate?
Company.
That's-
But there is right company. Registration,
No,
registration to Thailand.
Where is your registration certificate?
Your registration certificate?
My lord, page number 50.
50.
Correct. I'm sorry, my lord. It is a registered class 1A contractor, my lord.
Contract, that means a farm, my lord, not a company.
On following
It's 50.
name of the contractor, firm or company.
Correct, my lord.
It is registered as Badri Rai and Company.
Correct, my lord. And page 51 is the, my lord, the
that's a
certified
registration number.
firm, my lord, registration number.
So it is a firm.
Correct.
Firm. So do you have registration number?
Yes, my lord.
Which one?
Extreme left, right, my lord, left, my lord, extreme left, my lord.
Hmm?
Extreme left, my lord.
At the top.
Top, my lord, registration number, down below, REO.
Page 51.
Yes, 15,
50, my lord.
50, my lord.
50.
Page number 50.
Registration number.
Which one?
First column, my lord.
First column, registration
First
number,
column, my lord, yes.
name of the contractor, oblique firm, oblique company, my lord.
Huh. Pen is there already.
Yes, my lord, GST number, PAN number is there, my lord.
Pen number.
Only he has to
Huh.
put the original, my lord.
A partnership firm cannot have Aadhaar card in its name. It is only individual basis. It is citizen only.
Yes, my lord. Obey.
Right.
Right, my lord.
So that goes. This Aadhaar card goes. If it is, please understand,
My lord.
if it is a partnership firm, the bidder is a partnership firm, it cannot have Aadhaar card. See, the production of bidders, original identity proof, not authorized representatives. You have to read it. PAN card. PAN card is there. Number is there.
Yes.
Aadhaar card. I don't think this is possible.
Yes.
If he is an individual, yes. Then contract registration number. 51, page 50 fulfills it.
Yes, my lord.
Only question is
Whether he had produced-
production of the original.
Exactly, my lord. That is the
That
track, my lord.
PAN card and contract registration number.
My lord.
Page 50 is to be produced in original, right? Then the PAN card. Then why clause 26 was not indicated in letter dated 3/7/2025?
Yes, my lord.
By the executive engineer? Because deadline was 5/7.
Right, my lord. First one.
Yes, it was extended to 10. My lord is also.
Even if, yes, notwithstanding
Even after the. deadline.
Notwithstanding superintendent engineer's extension,
Yes.
if he is not accepting it by writing letter on 3/7, when the deadline was 5/7,
5/7.
right?
Right.
He could have indicated to meet the deficiencies. This letter is very vague. Let us admit he had received it. Let us admit for a moment. He could have done it 5/7 or 10/7 within 10/7.
Exactly, my lord.
Where is
Now supposing, my lord, he says that he has not.
this
Now, my lord, let-
reasoning?
Accept his argument, my lord. He says he has not received it, meaning that he doesn't know. His only case is that executive engineer is not.
Let us assume, sir, according to your that 3/7 you have issued.
Yeah.
And then was it not your duty to indicate it?
My lord, it's a-
Definitely.
Of course, my lord, it was broadly done.
Now let us see the reasoning.
But the petitioner's case is that he has not received it. His only case is that executive engineer was not present in the office.
No, the judgment is delivered on that point. Judgment is delivered on that point. Let us come to paragraph 21 onwards. Clause 26.
Yes.
Clause 26.
My lord.
Judgment is delivered.
Yes, my lord. Based on 26, correct.
You said it is not your case. His case.
Yes.
But judgment is delivered on that point. Let us read.
Judgment.
Penalty of the above clauses so that the process fee shall be collected from the division office from the assigned person and duly conducted by the assistant engineer by the bidder authorized representative on production of bidders original identity proof of the procedure. Pending which the processing fee shall be received or processing fee received no order sufficient rejected. The code clearly reveals that on 3/7 the petitioner through his authorized representative has submitted the required documents which are duly received. However, no original documents are produced before the authorities as required under clause 5 of the NIT and clause 26 of such result. It appears that the petitioner who is authorized representative has submitted his deeds on 3/7/2025 without furnishing the required documents or without production of the original documents such as PAN card, Aadhaar card, and contract registration certificate on the said day which amounts to non-fulfillment of clause 72 by dispute document condition of tender. Therefore, the contention of the petitioner due to short period of time for submission of tender, the continuous absence of executive engineer from the office during the period obtaining processing and submission of tenders from 13/6 to 5/7/2025 cannot be accepted. That was his case.
Yes.
Record also reveals.
On 3/7 referring to additional transport of contract that you did not use the original. Whereas the last date was up to 5/7 and 10/7. Because they can meet the deficiency. I wouldn't have time because it had been 5/7 years. It would have been. But on 3/7 you said, you did not, but without indicating what document you do. But he did not, they did not issue it. A produce will state hard.
My lord, may kindly appreciate, my lord.
I have heard enough.
Your-
The judgment is delivered from paragraph 21 or not the reasoning shown
My lord,
on 3/7. Let us admit on 3/7 the document was communicated.
my lord.
It was not his duty as a public servant to treat and act fairly. That yes, you said additional conditions of contract, which has 29 clauses, and it has clause 26,
My lord,
and clause 26 has many requirements. You could have pointed out 5/7 was the last date or 10/7 was the last date. Everybody could have met the deficiencies.
my lord,
Had it been 5/7 or 10/7, he rejected, we'd have accepted.
my lord, may kindly appreciate one thing. My lord, these were the parts of the tender document, my lord. So all the tender bidders, my lord, 4 bidders they participated. My lord. So since they are contract on register number 1, my lord, they
You
are
produce the document, we will release it. and annexed it.
my lord. Then another thing you lordship may kindly appreciate, my lord. The register which we maintain, my, that was produced before the court, my lord. When we filed the affidavit, my lord, the document which we have received, my lord, then we are directed to produce the register. Register was produced, my lord. In the register also,
Your whole case is based on 3-7.
my lord,
The judgment is delivered on 3-7.
it was communicated, my lord.
On
it is
clause
not, my
26.
lord. Absolutely. Now,
You are appearing for whom?
5 and 6.
5 and 6.
The
Exponent.
bidder who,
No, my lord.
whose bids were
The
accepted.
executive engineer and assistant engineer have been made party by name.
Okay.
My lord, now,
Oh, you were the party.
Who played the entire game?
no, that is the wrong submission, my lord.
My lord, while
If your
going
lordship-
for the records, my lord.
If your
the
lordship
client
appreciate, my
asked
lord,
for the record of the bank draft. His original bank.
Yes, yes.
my lord,
Yes,
kindly,
what is the benefit?
Yes, yes. It is
My-
with me, my lord.
kindly note, my lord. Original, my lord, bank grantee, it was supposed to be with the department. Now he's possessing, my lord. On what basis, my lord, he said, my lord, he tried to submit the original document. I fail to understand, my lord. Big documents, my lord. He says, my lord, he tried to submit, but executive engineer, my lord, or the official staff, they refused, my lord. But all the original document, my lord, he's having. He never tried to, my lord, submit the original document on, my lord, prior to 3-7, my lord. Register source, my lord, what are the documents he has produced, my lord? And that
Did
he
you
never-
submit the original?
Yes, my lord.
Yes,
I
my
made,
lord.
my
That is
bid
the wrong
security.
submission, my
my
lord.
lord, therefore, my
No,
lord.
no. One, you say clearly.
That is absolutely
We'll
the wrong
take your
submission.
statement as an officer of the court.
My lord. I went to the office of the executive.
One minute.
My lord.
Did you submit this? Or your document was not accepted at all?
My lord, my documents, original documents was not at all accepted, my lord. Original documents, my lord. The other bunch paper, my lord, which they have taken is of no use, my lord, unless documents original is
Page 80.
page 80, my lord. This is the crucial document, my lord, important document.
Did you submit it or not?
No, my lord. Original is with me, my lord.
That's it.
They refuse to, my lord, accept.
It's wrong.
My lord, original documents in
How can my lord?
EMD in original has to be, lordship has say seen in clause 8, 26, my lord, and the ground of rejection is also on that point, my lord. That you have not my lord, submitted the EMD in original and other documents for which, my lord, the rejection has been done, my lord, much before the, my lord, the late deadline, my lord. This is my precious case, my lord. Even in read petition, my lord, I have taken that ground also.
So why did you retain this then, page 80, bid security?
My lord, original documents, unless it is processed and, my lord, the accepted and processed, my lord, it will be of no use, my lord. Original EMD
Where is
document.
the register?
It's given us-
147, my lord, the handwritten. 148, sorry. 149 is a typo.
Serial number 3, my lord. What my friend is saying, my lord, not received. Where is set, my lord,
Was
forwarded to the PWD Yamcha division. It was forwarded, my lord. Whatever document was received from him, it was forwarded, my lord. So that is a wrong submission that we deny.
Received tender document from page number 1 to 46. You submitted something,
Yes, my lord. he
My lord,
they accepted.
Yes.
my lord, photocopy, my lord. Photocopy of these documents, my lord.
That-
Why
that-
did not you submit that original of
My lord,
this,
as per the, as per,
original of this page 80
my lord, as per the, my lord, the condition, my lord,
and
Is-
10,000?
or 10,000,
Is
my lord,
it your case that even 10,000 was not received?
my lord.
Huh?
Yes, my lord. My
In
lord,
cash?
my lord, in case, my lord, it is, my lord, categorically, we have made a statement in para, my lord, 4 of my read petition, my lord, page number 3, my lord.
What did you state?
Married, madam. Although the last date of the submissions of the original processing fee and EMD was 5th July 2025, the petitioner presents in the office of the executive engineer, respondent number 4, Yamcha so and so, from 2nd July 2025 to 5th July 2025. I'm sorry, Palade. With a Bailey bank draft of arrest 10,000, Bailey bank draft of arrest 10,000, dated 2nd July 2025, as processing fee. However, the subordinate official, despite being endorsed to receive the documents, unofficially acknowledged, unofficially acknowledged, that has not been processed, as I.
No, unofficially acknowledged, it should have
Well-
contained the bid security, EMD,
And
because page 95,
Well-
I have forwarded the said documents to EE Yomcha.
correct, madam. And they kept in the office room without initiating the official procedures, citing strict verbal instructions from the executive.
Let us have the records.
Yes, sir.
When can you produce it?
My lord.
Monday, my lord.
Relating to this, all these documents in original,
But whatever he has. submitted, my lord.
148,
Yes.
page 148,
140.
and prior to that. Heard Mr. Kato,
My lord.
M. Kato, Learned Counsel for the petition. Mr. Avam, Learned additional AG,
My lord. 1 to 4, my lord.
1 to 4. Mr.
Deepak, 5 and 6.
For the respondent of 5 and
5 and
6. Post up. The petitioner. Oh, sorry, the appellant. As the petitioner desired to participate in the tender process initiated by the invitation for bids IFB dated 36/2025, whereby the respondent number 4 as the tendering authority invited online item rate e-tendering in double bid system from registered and eligible contractor in of the category mentioned herein for a contract work, quote unquote, upgradation of Yomcha ADC HQ to Liro MOBA EAC HQ Road under CMC SRDP-Roman 2, page 58. First up, for submission of bids, it required deposit of earnest money of rupees 39,70,000 and cost of bidding document of rupees 10,000. Full stop. The case of the appellant as writ petitioner in brief, inter alia in brief, or in brief is that, in order to deposit, in order to deposit the processing fee of rupees 10,000 and EMD, which it prepared in favor of the respondent 4 on 2/7/2025 for an amount of rupees 39,70,000 as term deposit advice. It a representative went to the office of the respondent of 4, but for under one pretext or another, the same were not received by the office of the respondent number 4. First of it was conveyed that the respondent number 4 was not attending the office on those dates. First of. However, on 3/7/2025, the respondent number 4 stated to have communicated to the appellant, the read petitioner, that at the time of submission, stroke collection of processing fee, it was observed that the requirements stipulated under section 3 conditions of contract under additional special conditions of contract were not fulfilled. And it was informed that the bidder failing to fulfill the above condition of approved uploaded NIT would be treated as non-responsive. First of, it is relevant to mention, it is relevant to observe that the special conditions, additional special conditions of contract in section 3 of the bid document contained (29) clauses. First off, the communication by respondent number 4, communication dated 3/7/2025 of the respondent number 4 did not indicate the specific deficiency being thereby with regard to which of the clauses out of the 29 clauses the bid document, sorry, the documents, the requirements were not fulfilled by the petitioner. First off, it is also relevant to mention that initially the time for submission of bid processing fee, etc., processing fee, EMD, etc., was up to 5/7/2025. However, subsequently, the time was extended up to 10/7/2025. First off, the online bid submission, date of online bid submission was fixed as on, was up to 14/7/2025, right?
Yes.
First off, which document is there? First off, the respondent number 4 in his letter had never had not asked the appellant, the petitioner, to meet the deficiencies. First of, clause 26 of the special conditions of contract. Additional special conditions of contract. Read as under page 136. From the from the where is your registration certificate?
51. Page number 51.
From the registration certificate of the appellant writ petitioner. It is noticed that the petitioner is a partnership firm
My lord,
having registration number page 50 of the Assam Public Works Building Department and PAN number so and so. First off, a partnership firm may not have a Aadhaar card. First off, only condition for denying the appellant petitioner to participate in the bidding process for the contract work appeared to be non-submission of registration, contract registration document and PAN card in original on 3/7/2025 when the date of submission of such document in original were available up to 10/7/2025. Full stop. The judgment of the learned single judge has been rendered on clause 26 of the special additional conditions of contract, more particularly first of all, in such view of number, we are of the considered view that matter would require examination. Okay, as all the respondents are represented, we deem it proper to issue notice, making the notice returnable on next week. Monday. Mr. So-and-so.
Monday is a holiday, my lord. Second, my lord. Second. Monday is a holiday.
Okay, 2nd of
Second.
December,
Mhm.
2025, as so-and-so has appeared and accepted notice, issuance of formal notice and respectfully, Learned so-and-so additional advocate general shall produce the relevant records related to the issue leading to the relevant records leading to the issuance of the letter dated 3/7/2025 and relevant produce the file
Your lordship may also say, my lord, the register which you maintain, my lord, that the
and
document.
all the other relevant documents pertaining to the issue having regard to the fact situation obtaining in the case, the state respondents shall not proceed further with the bidding process pertaining to the contract or in.
My lord, may kindly note, my lord, that last date was 15/7, my lord. Now we are after almost 4 months, my lord.
You make-
So must have
getting
issued the, my lord, 10.
You produce the records.
All right.
Item number 4.
Oh, sorry.
No, no, that's fine. After request.
PL.
My lord, it's a PL.
PL on what subject?
My lord, it's a pertaining to construction of community wall. Yes. They says, my lord, we have, my lord, changed the
Who is the
location.
petitioner?
Petition, Mr. Nebo is seems absent, my lord. Mr. Nebo.
Today is for what?
Today is for, my lord, orders, my lord. Today is for orders.
It needs to be exchanged. Private respondent to file their affidavit in opposition.
Yes, but 10 to 7 they have filed. private.
They have filed.
Then for
Modi is still take any.
for government also, my lord, we have filed. Then department. Circle officer. तो आरबी का फाइल कर दिया कर दिया
Okay. So petitioner is not there.
Well,
Okay. The learned. Sorry. There is no representation on behalf of the petitioner today on call. Mr. So-and-so, learned edition advocate general, AP, and Mr. BP, so-and-so, learned counsel for the respondent number,
is the standing council for
standing counsel,
Yes, standing council RD.
R,
RD,
rural development,
Yes, ma'am.
for respondent number,
25678.
and Mr.
I'm Udeka for respondent number 10 to 17.
10 to 17 are present.
Private.
In view of non-representation on behalf of the petitioner today on call, let the case be listed after 2 weeks on a date to be fixed by the office.
Item number 5.
May I please, Lordship? Lordship, this is the applications which I found for the condemnations of a delay.
Okay, how
regard-
many, what is the conviction?
Conviction
sentence?
is 302, life imprisonment for 302 and 364, 367.
Where is the judgment in the connected case? Appeal.
It is in page 11 in my main appeal.
Okay, 11. How many days delay?
Delay, Your Honor, I have counted the date. That is the day I have procured the certificate, Your Honor, the judgment. That is of 23/4/2025.
What is
That-
what is the period of delay?
Period of delays is your Lordship. It's a one. I written 149, 150, Your Honor. 150 days. 150 days.
302?
Yes. 364.
Where is the sentence part?
Sentence part, Lordship. Page 47 of my main petitions.
450, 451, 364. Kidnapping,
Yes, Lordship.
302.
Yes.
367, 326.
Yes.
Liable.
Is it here too?
Yes, public prosecutor.
Yes, my lord, so far as the delay is concerned, my lord, I have no objection, my lord, it may be
Heard
condoned.
Miss
Dioka.
Yoka, learned counsel for the applicant. And Mr.
Tiyata, my lord.
Learned additional public prosecutor.
Yes, my lord.
For the respondent state, full stop. Now, instant interlocutory application under section 5 of the Limitation Act 1963 is prepared, seeking condonation of delay of
150.
50 days, which period stated to have occurred in preferring the accompanying criminal appeal under section 415 of the Bharatiya Nagorik Surakha Sanhita. Full stop. The applicant as the appellant has preferred the criminal appeal, accompanying criminal appeal against a judgment, an order dated 20/03/2025,
Yes, Lordship.
passed by the Court of Learned Sessions Judge, Khonsa Sessions Division, Tirap District, Arunachal Pradesh Trial Court, in Khonsa Sessions Case Number 34 of 2023. Full stop. By the judgment and order dated 20/03/2025, the trial court has convicted the appellant for the offences under sections page 46, para 72, 450, 451, 364, 302, 367, 336 of the Indian Penal Code. And for such convictions, the appellant has been sentenced in various manner. Full stop. For the offence under section 302 IPC, the appellant has been sentenced to undergo imprisonment for life, out of which first part of 10 years shall be spent under rigorous imprisonment, and to pay a fine of rupees 10,000. Full stop. The sentences passed against the appellant for convicting him for other offences are lesser than the sentence of imprisonment for life. Full stop. We have gone through the statements and environments made in the application, more particularly, paragraph 3 to 7 thereof. Full stop. Mr. Sorensen, an additional public prosecutor, has submitted that state has, since the petition has been sentenced to undergo imprisonment for life, the state has no objection. If the accompanying criminal appeal is hard on merits after considering the period of delay, full stop, having regard to the explanation provided in the interlocutory application, we have the considered view that the appellant has been able to made out, has provided sufficient explanations of showing sufficient cause for the period of delay. So in any view of the matter, this court is of the considered view that since the appellant has been sentenced to undergo imprisonment for life, along with other sentences which are to run concurrently.
It's not been clear here.
Not
It's not
clear.
been, no, it's not been written in that
Then it
judgment
is
here.
consecutive.
Consecutive, definitely.
লিখিব নালাগে। That since the period of delay is not substantive and the accompanying criminal appeal is required to be hard on merits after considering the period of delay of 150 days to stop. Accordingly, the instant interlocutory application is allowed first of the registry to register the accompanying criminal appeal and thereafter to list the same for admission.
Yes, sir. Obliged, Your Honor.
Item number 6.
Getting
Minutes,
over.
I seek to appear for the appellant minutes. The bench
Yes.
formation which was being indicated on the website, had indicated a formation whereby the matter could not be heard because Justice Karda Kete was the lawyer for the petitioner before the learned single judge. Therefore, we couldn't plan our visit accordingly.
Okay.
So we would humbly pray to your lordships to give us a date on which we can appear and come.
In fact, Adag is not there in the next week. Next week, Justice Karda Gete will not be here.
Yes, let's,
So we can
let's
decide on the date.
Let's, if it could be 22nd of December, then let's, we will
We
be
will
able
be
to,
having holiday
I'm told let's, the holidays are starting on 24th.
for 22nd. Can it be before some?
Ours is from 25th.
Okay,
I have no objection.
you have no objection. Okay,
Very well.
yes, you are for.
22nd December.
My name has been wrongly shown in the ACOS list. And since the senior counsel from the Delhi is appearing on behalf of the Union of India, my lord,
Ah.
in my lord, main read appeal, my lord, my name has been struck off, my lord. But in IEA,
You make an application. You have a registry, you will strike off. Okay, Mr.
Lordship.
22nd December.
Yes.
Mr. Kaushik.
Yes, my lord.
Yes, sir.
Okay, Mr. N. Kaushik, Learned Senior Counsel.
Along with
Assisted
Miss Seema
Appear.
Dolo.
through virtual mode along with Miss.
Seema Dolo.
Both are virtual.
Yes.
Okay. For the appellants and Mr. D. Pangi, Learned Counsel for the
Private
respondent.
respondent.
Poster. All are private.
No, Neris is also a party.
Huh?
Neris is a party.
Okay, for the private respondents. Who is the counsel for the Neris?
In fact, Mr. Apang is not keeping well, actually.
Okay, we don't know the Learned Standing Counsel for the
Yes.
respondent Neris authorities is not present today. Post of as sought for and agreed to by the Learned Counsel for the appearing parties list the appeal on 22nd December 2025.
Deeply.
We don't know today, Mr. So-and-so, the Learned Standing Counsel for the Neris is absent.
Yes, let's.
Anyway.
I will inform.
22nd.
Grateful.
Miss.
And Anju.
22nd is okay?
Yes.
Okay. Learned Counsel for the respondent Neris. What?
Deeply. My lord.
my lord,
Here,
may I mention item 4? This may be taken up after a week, my lord. State has filed a writ petition, my lord.
state has filed a writ petition.
Yes, my lord.
Yes.
After a week, my lord.
Why?
My lord, today,
It's a fixed matter.
yes, my lord. I have taken consent, my lord. I have taken consent from the other side.
Okay. Mr. So-and-so. Learned Counsel appearing for the respondent
For the petitioner, my lord.
or petitioner. Petitioners. Kama with the consent of the Learned Counsel for the respondents. Kama has made a prayer for adjournment and to list the case in the next week. First of, as sought for, list the case in the next week on a date to fix by the office.
My lord, there is a interim order that may be continued.
The interim order passed by the should continue till then.
Obliged, my lord.
Yes, Mr. T.
My lord, item 18 and 19,
Yes.
Lord, are connected with the land over which NFPC had started constructing the road. The allegation of the petitioner was that the work is being done on the road, on the land without the acquisition proceeding, without paying the compensation to them. Now, my lord, there are subsequent development. Acquisition proceeding is complete, I have been told, and there is some kind of a draft award or award, whatever it is. And the state government has to file an affidavit in this case, because last time the time was taken by them to file an affidavit to apprise the honorable court about the exact status.
Lordship, say the first day or the main case. Subsequently, many pleadings have been filed, but first date, this court directed the government to have a look at the first order.
First order.
247.
Page, item number.
This is 13.
Item number, my lord, 247, my lord. 18.
18.
The first order is yet to be, my lord, complied with. Government was asked to submit a report, let that report first
My
come.
lord, report, my lord, will be submitting with the affidavit, my lord. We have received it, my lord.
Report
Paraba's comments, my lord, we will submit.
Rest things will come later on, my lord.
If report is also with the affidavit, then
Yes, my lord, we
it
will.
will be better for all the
Yes,
parties.
My
correct,
lord,
correct.
kindly have a look.
Not I, main petition.
Not I has been disposed of.
There
Just
is
have a
one
look
more
at
I.
first order,
I
6625.
is alive, I think.
Yes, 6625 order. That's where the matter is started. Your lordship will take 2 minutes. Paragraph 5. Paragraph 5 and then paragraph 7.
So far as 66.68 hectare, no issue.
No issue.
Award
Lawfully acquired,
passed.
we are
Compensation
granted
received.
compensation.
Now,
So they started-
next is that beyond
That,
that,
there is the,
some land have been utilized.
then the last paragraph.
So,
Then
field
the last
survey,
paragraph.
field survey.
Page 8, paragraph 8.
Okay.
So
Now,
this-
field survey is ready, I think.
My
Done,
lord,
it was done.
Huh.
I think report is also with him.
my lord, it was done, my lord, it was produced for court, my lord. Then we've been asked to file in the form of affidavit.
Okay.
Now, since we have received the Paraba's come from the Deputy Commissioner, my lord, that report will annex with the affidavit, my lord.
Now, my lord, there is another thing. Thereafter, after the writ petition wherein, my lord, London Senior Counsel, Mr. Barbara is appearing, another writ petition was filed. And in that very writ petition, the petitioners of that petition said, they are not the owner, but they are the owner. So the dispute started as to who are the exact owners.
Let us have the field survey.
So that is why, my lord, let the affidavit be there.
Thereafter, principal court of civil jurisdiction.
That is it, number one. Number two, my lord, that.
Who is the owner?
Yes.
Who is the
That another-
rightful claimant for that
Precisely.
acquired land? After
Yes.
field survey, they will be relegated to
That's
principal
it.
court,
That's it.
civil
That's
court of
But
origin.
another aspect also, the so-called access area, it is acquired. Draft award is prepared. As to whether the approval is there or not there, only state government knows.
So
So, my lord, in the affidavit, they should place everything before the honorable court.
Yes, at least three things. One is field survey report,
Mhm.
petitioner's contention.
Yes,
Then whose land is
The
what?
other petitioner's contention will be
Yes.
addressed there.
yes.
If not, then that will be factual determination,
That's it.
who is the rightful owner
That's it.
and claimants.
The government will determine.
Second part, draft award,
Yes,
meaning thereby some stage
yes,
has reached,
yes,
then final award.
yes, that's it.
So NSPC is not determining who is getting how much hectares.
Since
We want money, my lord. We want to pay the money as soon as possible.
Since
That is what
additional
a government-
advocate general is saying that he is bringing on record the field survey report as well as draft award report and the final approval or not. it will
So,
be
so let us first have that
have the
report.
field report.
Yes, so-
Then
If the field report is there
yes.
and thereafter contentious issues regarding rightful claimants and
Yes,
owners,
yes,
that they will be relegated.
yes.
No, but at least the acquisition proceeding is very relevant.
Sure.
Because ultimately, my lord, we have to construct the road on that very particular land.
Heard Mr. A.C. Barbara Leonard. We'll pass the order in the writ petition.
Yes,
Keeping the eye-
yes,
Yeah, yeah,
yes, the- in the writ petition.
247.
A.C. Barbara Leonard, Senior Counsel, assisted by Mr.
And Swagia.
And
T.T. Tara.
Swagia, T.T. Tara. Learned Counsel for the Petitioners, Mr. R.H. Navam, Learned Additional Advocate General for the respondent number 1 to 5, and Mr. P.K. Tiwari, Learned Senior Counsel, assisted by Mr.
R.L. Tungan,
R.L. Tungan, Learned Counsel for the
6 and 7, my lord.
respondent number 6 and 7. Full stop. Mr. Navam has submitted that the field survey, comma, as observed in the order dated 6/6/2025, comma, regarding the parcels of land which are illicitly utilized for the
Construction of road.
construction of road has been complete in the meantime. Post of he has further submitted that a draft award.
No, my lord.
Okay.
Paraba's comments I have received from the
Okay,
Deputy
full stop.
Commissioner.
He has
Some hearing is going on.
He has further submitted that he has received the Paravoi's comments to file the affidavit or additional affidavit?
Affidavit.
Affidavit,
With
counter
report.
affidavit on behalf of the state respondents. Full stop. wherein he will bring the field survey report
My lord.
on record. Full stop. How much time?
My lord, since my lord, both the learned senior council, they are insisting on 18 December, my lord, it's okay.
18th of
18th
December.
December.
Okay. He has sought listing of the case on 18/12/2025.
25.
As by that time, or as on or before 18/12/2025,
Correct.
he will file the counter affidavit. Full stop. The
Eight, my lord, eight.
prayer.
My lord, may I just assist you? My lord has said, recorded that we will file counter affidavit.
No, no.
No, no.
Nabam.
Nabam now.
I-
We will respond to his, definitely we will have report.
Before 18, I said,
Yes.
you go through that.
And-
Thereafter, if you
Because
find,
Then we will
The
respond.
affidavit of the state may resolve all the issues.
okay,
Hopefully.
the prayer sought by the learned additional advocate general is accepted by the learned council for the other sides. Full stop. Place the case accordingly on 18/12/2025.
Well, after the report, we may have to file.
That is why I
Very well,
said
yes.
before 18/12, they filed the affidavit.
If
If
ne-
you have nothing to file, then on 18/12, it can be resolved.
My learned senior colleague has been to the spot itself, a spot verification.
Okay, okay.
Not go there,
No,
represent the NSPC, but he has been to the spot.
Suppose he files it on 17,
Arunachal is a beautiful state.
suppose he files it on 17, Lordship will definitely.
Nobody should miss the opportunity.
Suppose he files it on 17 in the previous day, naturally Lordship will accommodate me sometime to response. That is understood, that is understood,
If required.
if required.
That be so.
Lordship, Lordship.
May I, your lordship?
Lordship in that, may I please, your lordship?
Who is for the petitioner in 19?
Yes, lordship, I am lordship.
Mr.
T. Garam, lordship.
We have.
T. Garam.
Lordship.
Same order, the Lord.
Same
Same
order.
order.
Learned council for the petitioners in 19.
Correct.
Huh?
Opposing each other, the Lord. He's opposing Mr. Barbara.
No, that may be defined parcel of lands. I am the owner here, he is the owner there, but report has been called for only in my case, not in his. It is simply said.
Okay.
So same order will
I
not
said
come.
6/6/2025.
So this order, same order will not come here, simply tag.
6/6/2025 passed in WPC number
Tag.
247/2000.
Lordship, in my case also, the government has to file the affidavit, lordship.
Let us have that affidavit.
Lordship. Briefly,
May I, your lordship? Lordship, I beg to mention item number 9, your lordship.
9.
Yes, your lordship. Can it be
Yes.
fixed on 10th of December, your lordship? I've taken the consent, your lordship.
Okay. On the prayer of Mr.
Y. Ram, your lordship.
Learned council for the
Government advocate, your lordship.
Learned State Council. Place the case on 10/12. It is submitted that consent has been taken from the Learned Council for the petitioner to make the prayer.
I'm there for petition.
Mr. Kaushik? Well, okay. It is Mr. Kaushik, Learned Council for the petitioner who is in attendance, has submitted that he has no objection to the prayer, but so raise the case accordingly on 10/12.
And one more, your lordship. Item number 33, your lordship.
33. Yes,
Here also, your lordship, may it be fixed on 9th of December, your lordship.
let it be second week of December. On the
Okay,
prayer of
Your
Mr. So-and-so, raise the case on a date in the second week of December. Full stop, it is submitted with consent. Petition side is available.
Yes, your lord. No, I have taken the consent, your lordship.
Consent has been, it is submitted that consent has been taken from the Learned Council for the petitioner to make the prayer.
Oblige, your lordship.
May I, lordship? Lordship, I beg to mention one unlisted contempt petition, lordship. For
Unlisted contempt, no urgency.
lordship.
List, it will be listed. Not today.
Lordship, tomorrow.
Tomorrow, I am told it is holiday,
It's holiday, yes.
Wednesday.
Lunch.
May I please, your lordship? Item lordship 5 to 8, my
5
lord,
to 8.
5 to 8. Learned Senior Counsel, Mr. Ken Chaudhary was appearing in this case.
Yes.
Is appearing in this case. Today he is unable to come
I'm requesting a next date, Lordship.
He is from petitioner side.
Yes, in item 5,
Hmm.
IA in item 5, then item 6 and item 8 in the petitioner side. Then in item
Six, item.
item 5, IA,
IA.
in the read petition, in item 5 is we are for the respondents.
In which petition he is for the petitioner side?
In 6 and 8.
6 and 8.
Yes.
Okay.
I am appearing for the respondents in this case. I have got some.
In 6 and 8.
My lord, I have got some objection in the sense, my lord. Here is a case where this date was fixed in the presence of both the parties. Now, it's causing a serious hardship to my clients, my lord. There was an interim order, a gradation list was challenged. All are, my lord, assistant engineers. The gradation list was challenged by them. Initially, ex parte stay was granted that not to conduct any DPC, etc. Thereafter, we filed an IA for vacating the interim order. After hearing all the sides, my lord, including the government, the interim order was vacated. Pursuant to that, my lord, the benefit of the interim order, the order passed vacating the interim order was that all the 4 respondents for which I am appearing, they should be promoted. Accordingly, 2 persons were promoted by convening a DPC. For the remaining 2 persons, when the fresh DPC was convened, then they came up with another IA. And my lord, there is no appeal against the first order vacating the interim order. Now, in the second IA, my lord, an order has been passed on 3/9/2025 that let the DPC continue proceedings and no final decision should be taken till the next date.
My lord.
And my lord, I am saying that without causing any prejudice to the petitioners. Now there are 7 vacancies are there. 3 posts may be kept reserved for them. They should not have any objection for that, my lord. When I am not coming in their way for till final decision, my lord, if your lordship reserves 3 posts for them, they are not, that also I am agreeing. Because there are 5 vacancies.
What is your instruction?
My lord, the matter is much more complicated than it sounds, my lord. What happened is, my lord, in the read
What is the
petition,
instruction? Why Mr. Chaudhary is not able?
my lord, he's having some personal difficulties. I'm told that his chamber junior is getting married.
Let the matter reach, I'll explain your lordship. Without affecting them, if your lordship can pass.
No, it cannot be like that, my lord, because the thing is much more complicated than he has made out.
When
in item
again?
a short date may be given, my lord.
We are also accountable to our clients, my lord. Last 2 days after this 3/9/2025, one more date was fixed. Somehow it could not be taken.
That was, my lord.
Today is the 3rd day.
That was, my lord. One of the dates was not there because of the impeachment, my lord. From them, my lord.
Without filing an appeal against the order by which the interim order was vacated, by filing a fresh application, if again the same order is restored in an indirect manner, this is causing serious prejudice.
No, my lord. It is not like that, my lord.
Another page of respondents here. Another page of direct groups.
You are petitioners or?
So there is no question of making any reservations in respect to the petitioner because I am contesting their case.
And my lord, these are under the things are under subsequent development, my lord. It is not the same situation it was then, my lord.
Thereafter,
Let the
we'll
matter
discuss.
reach, yes.
We'll
My lord, I'm not in a position to argue.
we'll try to accommodate.
Yes, my lord.
You are also there.
Yes, my lord. But my lord, my case is different, my lord. But it is clubbed together, my lord. Item number 7, my lord. May I present, my lord? My lord.
Let the matters be called and you make a prayer.
My lord, senior advocate Ken Chaudhary instructed me to adjourn the matter to the my lord. Item number 11, 12, 13, 14 and 15, my lord.
Oh, 11 to 15.
Yes, my lord.
You are for the petitioner.
Yes, my lord.
I'm for the Union of India as well as my lord, the SCKL, my lord, who is appearing on behalf of GST department, my lord. As consented by my lord, matter may be listed on 12/12, my lord, next week.
12/12?
My lord. 12/12. As instructed by my lord.
Yes.
Okay, ma'am. My lord, in item number 11, there is an interim order that may be continued.
Okay, Mr. Gao.
No, Ado, ma'am.
Diado. Learned Council has submitted that Mr. Ken Chaudhary, Learned Senior Counsel, is leading him in these cases. And Mr. Chaudhary has personal difficulty today to appear. First up, he has submitted, with the consent of Mr. So-and-so, learned
Yes.
counsel appearing for the respondent GST authorities, to list the cases on 11/12,
12.
2025. So stop. As sought for and agreed to by the learned counsel for the parties, list the cases on 12/12. The interim order, if any, shall continue till the next date of listing.
My lord, interim order is there in 14 and 15 of them.
Interim orders.
Yes, ma'am.
Wherever passed earlier,
Okay.
shall continue till the next date.
Lordship, I would like to mention item number 25, Your Lordship. Lordship may
25,
kindly take up this matter after 3 weeks.
25, 26,
25 only, Your Lordship.
25.
Yes, Your Lordship.
Okay.
We have to file
These are
evidence.
orders, let us see.
Hello.
Maybe some service.
Yeah, Your Lordship. Lordship, item number 32, Your Lordship. In this matter, records were called for pertaining to the procedure adopted by the Commission in weeding out of the records, Your Lordship. So I'm yet to receive the records. Can this matter be fixed after 4 weeks, Your Lordship?
Okay, who is for the petitioners?
I'm for the petitioner, Your Lordship.
You are for the petition.
Yes, Your Lord, for Commission APPAC.
Who will produce the records?
I will produce. Commission has to produce before this court, Your Lordship, regarding pertaining to the records.
Item number 22.
32, Your Lordship.
32.
Yes, Your Lordship.
Okay. Miss
And Anju.
and Anju, learned counsel for the petitioner, has submitted that the relevant records are required to be produced. I have not yet been received by her and has short listing of the cases after 4 weeks. So, Mr. You were there for the hours,
I have-
Rakia?
Yes, Your Lordship. I've
You are
taken the
present?
consent, Your Lordship. I've taken
have
the consent.
informed?
Yes, Your Lordship.
Okay, it is submitted that consent has been taken from the learned counsel for the respondents to make their prayer. So, place the case accordingly after 4 weeks on
Obliged.
by the office.
Obliged.
Lordship, I beg to mention item number 26 and 27, Lordship. In this case, government has already filed their affidavit, Lordship. So we need
Yeah,
some more
orders,
time.
wait for some time,
We need
some
to
orders
file
may be
replies.
etc. Maybe service, etc. Let us see. Your prayer will be allowed.
Item number 1.
Yes, agree by adoption of multiplication or?
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
Yes.
My lord, there is a provision for challenging that, my lord.
Is it?
Basically, it's the compensation, my lord, the quantum.
2013.
Yes, my lord, section 6.
So multiplication.
Basically, whatever multiplication also, it will amount to the compensation, my lord. The quantum of compensation, my lord. That also, if he is aggrieved, section 64 will apply, my lord. So,
Yes, what is your case?
And Your Lordship, here,
64, RFCT, 2013 Act, land acquisition.
yes,
Lordship, but there's a provision to file, statutory provision to file direct, statutory provision to file direct High Court.
So for multiplication, you are not agreeable to multiplication factor 1.
Yes, Your
You want for 1.4.
yes.
That is your case.
Yes.
Where is the multiplication factor? Provision for multiplication factor?
Lordship,
Parameters to be considered. Yes,
no-
where is the multiplication factor, Mr. State Council?
it will be in the schedule, my lord,
schedule of
First schedule.
first schedule.
point number 2, Your Lordship. That's it.
Point number 2. So it should be between 1 and 2.
Yes.
It should be between
Yes.
1 and 2.
But this notification of
In
9 January
exercise or
2015, it's
Section 30. we need
prescribe
to-
this petitioner's lane is 21.
Where is the notification?
Annexure 1, page number 29,
Page?
Your Lordship. Page 29.
29.
Yes, Your Lordship.
So it is between 1.0 to 2.0.
Yes,
Now it is a question of applicability.
this radial distance shows, Lordship, you may see in annexure 1B.
No, madam, it is question of applicability.
Yes,
1.4 is already there,
yes, Your
right? Radial distance is already there.
Yes, Your Lordship.
It is question of applicability
Yes, yes.
by the authority.
Yes.
Competent authority like deputy commissioner,
Yes, yes, Your
right?
Lordship. Yes.
And he applied 1.0.
Yes. Yes,
According to you, it should have been 1.4. Is it not within the province of the referral authority
Not,
under section 64, as he has said?
not Lordship, even in award also, they have stated they will apply multi-factor. Here in page number,
Because 64.1 it contains that your objection as to the amount of compensation.
yes, Lordship,
Measurement of land, there is no doubt.
no doubt. Yes.
So it is the amount of compensation and applicability of the multiplication factor.
Yes, it ought to be applied by 1.4 multi-factor.
So if you lead evidence
Yes,
before the referral authority, then accordingly amount will be increased if you are entitled for the same.
yes, but
Now, did you file any application?
but
Did you file any application before the district
yes,
commissioner?
yeah, annexure for page number 43, sir.
43.
Yes.
Now, where is the Mr. State Council?
Yes, madam.
When an application is filed,
Yes, madam.
by written application to the collector.
Correct.
So this can be treated as an application.
Yes, this, for this, we can, what has been done, that
Take your
instruction-
instruction
Yes.
by Thursday. This can be referred to the referral
To the
authority
authority.
and get the instruction who is the referral authority. He will refer the application, this page 43 application regarding multiplication factor. Have you said so, 1.4?
Yes.
Mm. Neither the distance have been mentioned, nor the,
In the writ petition you have preferred.
Yes, this have been mentioned here.
In your representation, not. Because section 64 says
Yes. Okay.
by written application to the collector, right?
Yes.
Here you raise the issue, multiplication factor.
Yes.
But there, here, you have not raised that 1.4 should be applicable.
Yes.
That aerial distance of your land. So take your instruction, referral authority.
yes,
Otherwise, we'll say that she will submit an application, the petitioner will submit an application before the collector within 7 days regarding raising the question of multiplication factor of 1.4 instead of 1.0. And on submission of such an application, the collector will forward it to the referral authority. And who is the referral authority? Take your instruction. Then you need evidence that more than 20 kilometer is the radial distance. So 1.4.
Yes, Your Lordship.
Then your award will be passed.
Yes, Your Lordship.
Already you have received the amount
Yes, yes,
for 1.0.
yes.
Okay, heard, Miss.
MLA.
Land Council for the petitioner, Mr.
N. Ratan.
N. Ratan, Learned State Council, has sought for listing of the case on Thursday in order to complete his instructions. We'll dispose of them.
Yes, sir.
You need any copy? Extra copy?
Madam, I'll download it.
Extra copy of the repetition you require?
Yes, and yes.
Ms. So-and-so, Land Council for the petition shall furnish an extra copy of the repetition along with an extra during the course of the day to Mr. Ratan during the course of the day to enable him to take necessary steps from his end. You furnish a copy to him today.
Item number 2.
May I
Well,
please
it's a
look-
notice at this stage.
Okay, yes.
Heard, Mr.
X getting.
Learned Council for the petitioner. Petitioners. Mr. State Council for the response number
1 to 4.
1 to 4. The petitioners state that they belong to Tagin tribe.
Yes.
Full stop. The petitioners have referred to a notification dated 23/9/2024 of the General Administration Department, Government of Arunachal Pradesh, whereby the holidays for the state of Arunachal Pradesh had been declared. Full stop. As per the said notification, the day, 6/1/2025 was in the list of local holidays for the festival, quote, SI-DONYI, unquote, which is a festival for Tagin tribe. Full stop. The petitioners are aggrieved by inclusion of their local festival as SI-DONYI HIOLO, which has been included as a local festival for Tagin tribe in the local holiday list published by the GAD, Government of Arunachal Pradesh in its letter dated 21/10/2024. Full stop. According to the petitioners,
Lordship, 20 December 2024 date.
2110, page 31,
Page 35.
35.
Yes. I'm agreed
Post
by
of-
this infant order. Page 35.
By another notification dated 20/12/2024, comma, the name of the festival, comma, SIDONYE for Tagin tribe had been substituted by SIDONYE HILO in a list of local holidays.
Lordship, sorry for interruption. Not substituted. It has been suffix added. This word, below word has been added.
Has been substituted, full stop. Land Council for the petitioners has submitted that the word, comma, HILO has been added to the local festival's name, SIDONYE, at the instance of the respondent number 5. Full stop. According to the petitioners, the festival for Tagin tribe should remain as SIDONYE.
And YI.
YDONYI. Full stop. Issue notice, returnable 4 weeks. Returnable in 4 weeks, as Mr. So-and-so has appeared, accepted notice on behalf of the respondent number 1 to 4. Issues a formal notice to the said respondents is dispensed with. However, requisite number of extra copies of the writ petition along with annexer are to be furnished to Mr. So-and-so. Within 2 working days from today, the petition shall take steps for service of notice of the respondent number 5 by speed post within 2 working days from today.
Okay, all right.
Item number 3.
Wait. But the readings are complete. Can it be taken up for disposal?
Today or when? Disposal, when?
Today, if your lordship, it will be discussed.
Okay, then let the other matter, then we'll take up. Or Wednesday.
Today.
If it is not inconvenient.
Okay, let us take up the other matter, then we'll take up.
Right.
Item number 5 to 8.
There is
Well,
some
in this
contentious
item, my lord,
issues.
we are also facing my lord, problem because DCP is already over, my lord. Now we cannot give regular promotion. We have been asked not to give, my lord. The seal pack procedure is stopped. So, my lord, there is sort of the staff officers also, my lord, in the department, my lord. So last time also I insisted, my lord, instead of my lord seal pack procedure, let there be one line, my lord, subject to the. Again, my lord, I'll be pleading the same, my lord.
No.
So there is a shortage of officers, my lord. For that purpose, DPC was conducted.
My lord, please, my lord. Writ petition 14. That is in item number 6. This was initially filed by the writ petitioners because they are the promotees. The respondents represented by my learned senior are direct recruitees. Now, what happened because there was lack of DPC for so many years, it was finally conducted in 2019. They were given promotion from the date of the DPC, losing all those years, my lord. So that is why they had approached the authorities and authorities has set up a committee. They were to consider the same, it was not considered. So therefore, this writ petition was filed. Later on, without considering, the committee had said, earlier said that it will consider everything, the seniority vis-a-vis the direct recruitees. It was not done and a seniority list was prepared. That is why writ petition 295 was filed. The one Ms. Learned Senior was referring to. That time, during the motion hearing, interim order was passed saying that DPC will not be conducted. But later on it was vacated, that was vacated. Now what happened is subsequently, after seeing all the representations and the committee members' recommendation earlier, the government had decided to constitute a committee again, second committee, I would say, and that was challenged by the writ petitioners in 284. That is in item number 5 by Mr. Pangeng's clients. So that is why an interim order was passed in that case, saying that the committee will not its constitution of committee itself was stayed. So therefore, we filed IA number 2117, saying that the interim order should be modified, and the committee should be the committee report should be made public. Now the government is in the process of considering our prayers, which are long pending, my lord. So that is why we had filed another IA saying that the DPC will not should not be conducted. That is in IA, that is 218 or in item number 8. So that is why I was saying the circumstances under which the previous DPC was stayed and then modified, that is different from the circumstances now. So that is why we had filed this IA. And when the IA was filed, of course, it was decided that the matters will be heard in toto, all the without hearing part. So that is why interim order was passed on 39/2025, which my learned senior was referring to, saying that DPC may be held, but it will be kept under seal cover. Now the next date was on 17/9/25. On that date, if I remember correctly, there was a paucity of time, therefore it was not taken up, and next date was fixed. Next date was fixed on 26/9/25, but that day also matter could not be taken up because they had filed an implegnment petition in the WPC 14. So it was decided that the matter will be heard on 28/10/2025. On 28/2025, your lordship may see the order. Upon hearing submissions by the learned counsel for this court finds that all concerned interlocutory applications arising out of their respective writ petitions can be decided along with the writ petitions. So the court had decided that everything will be heard in total. So my prayer today is, my lord, I'm not in a position to argue the matter today because the matter was to be argued by learned senior counsel K. N.
It was
Chaudhary.
a consensus decision for admission hearing.
Yes. Lordship may see all the orders, lordship. Thereafter, after 39/25.
Just couple of minutes, I'll just.
Do you have any interim application?
No, madam, my further application. No, further application not necessary.
No, do you have any interim application?
No.
IA?
I is by them.
IA is filed by us. Yes.
Well, I'm making the.
We are only seeking, my lord, a very short date, my lord, if possible, my lord.
Madam, the position is like this. We are the direct recruit of 2019. Sorry, 2009. 2009, my lord, 24th August 2009, we were appointed directly to the post of assistant engineer. In 2019, my lord, they who were working on officiating basis as assistant engineer, because they were initially appointed as junior engineer, they were regularized. Their officiating promotion was regularized in 2019, 10 years after we were directly recruited.
You were appointed?
2009.
Okay.
10 years thereafter, they were regularized. Their officiating promotion was regularized. Thereafter, a gradation list was prepared. Before gradation list was prepared, my lord, when they were regularized in 2019, the order was passed on 17/1/2020. With effect from 31/10/2019, they were regularized from the date of the DPC. They have challenged this order in WPC number 14 of 22, saying that no, we should have been promoted with a retrospective effect from the date we were officiating. There is no interim order in that case. The writ petition is still pending. It is in this batch, I think. Subsequently, when there was no stay, etc., a gradation list was prepared. Naturally, in the gradation list, we were direct recruit of 2009. We were above them. They have filed a writ petition, the present writ petition 295. In the writ petition, they have challenged the gradation list. There is an interim order that in the interim, no further promotion to the post of executive engineer from the post of assistant engineer be made on the basis of the said gradation list. That was the interim order. Then we entered appearance, we filed an application for vacating the interim order. That interim order, Your Lordship, just have a look at 2 paragraphs from that order, my lord, passed by Honorable Justice Surana. Page 31 is that order, my lord. Just 2 paragraphs I'll show and then I'll just sum up.
Wherein?
Well, it is in IA filed by them 218. IA 218.
218.
Yes, just two paragraphs.
218.
Yes. Lordship has got my
Page
31. This is the order dated 18/9/2024. Page 31, madam. Lordship has got my. So Lordship may kindly turn to page 32, paragraph 3. Page 32, madam. Lordship has got my. Page 32, paragraph 3. By filing this interlocutory application under 226(3) of the Constitution of India, the applicants have prayed for vacating, modifying, and/or not extending the ex parte interim order dated 31/7/2024 passed in connection with WPC so. It would be pertinent to mention that by the said order dated 31/7/2024, while issuing notice, this court had found it fit to direct the state response may not conduct DPC with respect to the promotion from the post of assistant engineer C to executive engineer C based on the impugned seniority list dated 29/7/2022 till the next date, returnable date. Now, Lordship will kindly see para 5. It is submitted at the bar that opposite party number 1, 2, and 3 had also filed WPC number 14 being aggrieved by the regularization of their promotion to the post of assistant engineer in the Department of Hydropower Development with effect from 31/10/2009, which I submitted. This was the first writ petition. Now, Lordship will kindly see para 7. I'll just, in short, narrate, my lord. The learned senior counsel for the applicants, by referring to the copy of the DPC minutes dated 24/7/2012, annexed to this interlocutory application, has been able to demonstrate that by the said DPC minutes dated 24/7/2012, a recommendation was made for regularization of officiating promotion given to 20 officers in the grade of junior engineer to the post of assistant engineer with effect from the date shown against their each name. The last 2 recommended officers by DPC minus dated 24/7/2012, serial number 19 and C. Swenso, whose date of promotion regulation was shown as so, and the last officers, Ama Palo, whose date of Swenso was shown as Swenso. The code by judgment in order dated 26/10/2021 passed in WPC number Swenso arrived at a conclusion that the aforesaid Imi Angu and Ama Palo, who had been arraigned as number 6 and 7 in the said writ petition, were recommended by the DPC in excess of the quota for promotion as per the recruitment rules 1991 as well as 2005. The relevant paragraphs are Swenso. The Lordship did not read all these things, my lord. Then Lordship will go to page 35. I'll narrate this, my lord, about this writ petition. 35, my lord. Page 35, paragraph 9. Therefore, in the light of the observation made in the order passed in WPC number 66 AP of 2013, and taking note of the DPC minutes dated 24/7/2012, which is annexed to this interlocutory application, the inevitable impression of the court is that in the connected repetition, there is WPC number 295 or 24, which where this IA is in this repetition, my lord. The opposite party number 1 to 3, that is the repetitions, my lord, suppress the said DPC minutes dated 24/7/2012. It is not in dispute that applicants herein were selected and recommended by the APSC, and accordingly by an order dated 24/8/2009, the government of Arunachal Pradesh through Department of Hydropower Development had appointed the 4 applicants herein as assistant engineer in the said department. It is needless to mention that as the said DPC meetings has neither been annexed by the office party number 123 either in so-and-so or in WPC number so-and-so. The applicants herein all are direct recruits of the post of assistant engineer. From the judgment of WPC 66 APSC 13, it appears that out of 20 recommendations made by the APSC, 2 recommendations were held to be in excess. All the remaining 18 junior engineers, therefore, got promoted to the post of assistant engineer. There is nothing on record to show that petitioners had challenged the DPC minutes dated 24/7/2012 or any other orders of the promotions which was issued by the competent authority for the 18 other recommended officers. Now, my lord, I'll take your lordship to page 38, straightway, para 19. Accordingly, in the light of the discussion above, the court is of the considered opinion that the stay order granted by the order dated 31/7/2024, directing the state responsible not to conduct DPC with respect to the promotion from the post of assistant engineer to the next higher post of executive engineer, based on seniority listed 29/7/2022, is required to be vacated as the position of the petitioners being direct recruits of the year 2009 ought not to be allowed to stagnate without any further DPC, as it is seen from the final gradation list that except for the applicants who are direct recruits of 2009, all other promotees of DPC dated 24/7/2012 and all the direct recruits appointed in the year 2006 are holding the higher post of executive engineers on officiating basis. Therefore, this is a case where the stay is likely to cause hardship to the applicants. This is how it was vacated. My lordship has seen, I'm just clarifying one thing. In page 40, lordship will kindly see for a moment, my lord. After this interim order was vacated by this order, my lord, this order was passed on 20th November 2024. Lordship will kindly see 15 and 16 are the total 16 persons were considered after the stay was vacated. Among the 4 applicants, my lord, who filed this IA and the order was vacated, 2 persons could be considered. I see the number 15 and 16. The remaining 2, my lord, could not be considered because there were no vacancy. Now, after when the new vacancies arose and new DPC is convened, my lord, and it is already now conducted as per the interim order, this honorable court, my lord, at their instance passed again an order on 3/9/2025 saying that DPC may proceed but result may not be declared. Now, my submission before your lordship, when this honorable court has already passed an order vacating the interim order, giving relief to the 4 respondents to be considered for promotion, 2 have already been considered. For the remaining 2, they have again come up with another IA without filing any appeal against this order by which the interim order was vacated. And the duty paucity of time only court said, since the DPC is going to be held tomorrow, they came just 1 day ahead of time. Since the DPC is going to be held tomorrow, I am only saying that let the DPC be held, but no final result. Now, lordship has seen in this page 33, my lord, this honorable court, while vacating the interim order, also referred to 2 things, my lord. That in WPC 66 of AP 2013, there was, in fact, 2012, there was a DPC. 20 persons were recommended.
It was an intra-party order, 3/9/2025.
Yes. In this order vacating the interim order, this honorable court has taken into consideration a DPC of 2020 to 12, where, my lord, all the vacancies were exhausted by that DPC. But out of the 20, my lord, 2 persons promotion and recommendation was subsequently set
Now,
aside.
who are these new party respondents?
Madam.
You were newly implemented party respondent.
No, my lord. No.
In WBC 14,
My lord, the first writ
So many
petition.
orders are passed. It is very difficult for.
Madam, I'm clarifying. The first writ petition.
One is 235 AP applicants, Jobom Bam, Donia Lolen, respond number 11, 12, 13, and 14.
My lord,
That is we.
You are the.
Yes.
Okay.
In WPC 14, Miller, that petition was instituted without making us a party. As the orders.
My lord, I'm clarifying. The first writ petition filed by these petitioners, my lord, was challenging their own recommendation, regularization, because that was prospective in effect. In that petition, they did not make us party. So we have filed an application for implementing the first writ petition.
Yes, madam, firstly, when he is available, or otherwise we can fix it on day after tomorrow,
My lord, a very short date, my lord.
day after tomorrow.
Day after tomorrow, my lord.
You can get prepared.
My lord, my clients would prefer him
Or
to
they
appear.
can
They
appear
have,
virtually also if it is difficult for them.
my lord, may I come back after some time?
You can come back. One prayer is made, that
Well-
can be respected. That can be expected.
Otherwise, what I was saying is, my lord, as on today, he will be a vacancy position too. There are 7 vacancies are there, my lord. If they are at all, my lord, apprehensive, 3 posts can be.
How many are the petitioner?
3, my lord.
3.
Lordship, through RTI, we have.
3, yours 2.
Ours is 2, 5. So still.
Yes, Mr. Additional Advocate General.
My lord.
What do you say?
My lord, that what exactly I have submitted, my lord. Now, my lord, DPs has been conducted and we've been asked to go for seal cover proceeding, my lord. Now, the agent debt vacancy, my lord, I'm not disputing, my lord. Yes, my lord. 7 posts are, my lord, clear cut vacancy are there, my lord. And as I've submitted, my lord, that we also need manpower, my lord. So your lordship can.
5 plus 2, 7.
Yes, 5 plus 2, 7.
How many? 2 applicants are left.
2 plus then the petitioner, my lord, 3. 3 plus 2, 5. So still 2 posts left out, my lord. So the key case is.
What is your case?
I am also senior to the writ petitioner, so there is no question of keeping any reservation related to the petitioners.
No, I'm not. Court may not reserve them for them, exclusively for them. Question is making the way for the applicant.
What your lordship can say, my lord. Your lordship may kindly allow us to give them promotion, but it's subject to outcome of the, my lord, so and so, my lord.
He is making a prayer.
And the
So we
2
can
persons.
propose it day after tomorrow.
My lord, I'll have a word and after
And
2 p.m. my lord.
2 of the 4 applicants who have been given promotion, my lord, that is also subject to outcome of the.
Yes, my lord.
My lord, in any case, my lord, in order dated 30 May 2025, committee was constituted to examine our representations.
The cases are listed for hearing.
Yes.
Admission hearing.
Yes.
So otherwise there is it is an inter-party order.
Yes.
It could continue.
My lord, after some time,
After some time or otherwise in the next week, which date?
my lord, next week, my lord, next week.
Mr. Mazumdar, when you are coming in the next week?
Third, 2nd or 3rd.
Lordship.
In fact,
Your lordship can
Because
find-
it is an inter-party order otherwise.
yes,
Matters are fixed for admission hearing. It will
Yes.
be disposed of. End of the matter, why subject to outcome?
my lord. If it can be taken up on 2nd or 3rd, even then I know.
Further opportunity.
Yes, my lord.
No prayer for adjournment.
Yes,
No prayer for
yes, my lord.
from the petition.
Even if he cannot come, we'll try to make by VC.
Why not, my lord? Day after tomorrow, Mr. Chaudhary can argue through BC also, my lord.
No, I had a word with Mr. Chaudhary. He said he'll be able to come before 4, maybe by VC.
We
that
can
is for
put it on 2nd of December.
Yes, my lord.
Madam,
Yes,
and
my lord.
Without any prayer for adjournment,
Yes, my
it will
lord.
be taken up for
Disposal.
here.
Yes. I will not be able to appear. Mr. Chaudhary will appear.
You are there.
Yes.
If not, make a provision for it.
Because it is what the clients.
No opportunity
Yes.
for adjournment.
Yes, my lord.
No prayer for adjournment will be accepted
Yes, my lord.
from the petitioner side.
Yes, my lord.
Done. Yes, Mr. Mazumdar, will be.
2nd or 3rd.
The Panging is okay. Second.
It will be third.
Third.
All right.
Third is a Tuesday, that's why I'm saying.
No, third is a
Wait,
Tuesday.
it is a Wednesday.
No, third is a Wednesday.
Wednesday will be
Second is the
best day, my lord. Because Monday we.
I was saying Tuesday because if
Monday.
there is a spillover also, they can.
Tuesday could
On
be.
second, I've got some difficulty. Let's be third.
Okay.
third.
Okay, obliged.
Some matters are fixed then, government matters.
Okay.
Obliged, my lord.
And
Duncan.
Nang, Learned Council for the petitioners.
Yes.
D. Mazumdar, Learned Senior Counsel, estate by Mr. B. Kaushik. Learned Counsel for the private and Mr. D. Pangi. learned counsel for the private respondents, and Mr. Arich Navam, learned additional advocate general for the respondent. State respondent are present. Post of Miss So-and-so, learned counsel for the petitioner, has made a prayer for objection, which has been objected to by Mr. Mojumdar, learned senior counsel, appearing for the respondent number, private respondents.
2 to 5.
Post of it is submitted to 2 to 5. Somewhere it is different. Private respondents.
Applicants.
Yes, you're not applicants anywhere.
No, not in the writ petition.
You're not
Yeah.
private respondents. So Mr. Mojumdar has submitted that as on date, 7 number of posts of executive engineer are vacant. And the petitioners who are staking claim for the said post by way of promotion
With
is
retrospective.
retrospective effect is only 3. Only 3?
Three.
Are only 3. Post of the private out of the 4 private respondents, 2 have already been promoted to the post of executive engineer.
Subject to outcome of the writ petition.
And their promotions have been made subject to the outcome of the writ petition. Post of the remaining 2 private respondents are also direct recruitees of the year 2009, as like the 2 private respondents who have already been promoted to the post of executive engineer.
Right.
Post of. He has thus submitted that if the DPC is allowed to consider the cases of the remaining 2 private respondents, the petitioners are not, the 3 petitioners are not going to suffer any prejudice. Are considered, and decision of the DPC is made subject to the outcome of the writ petitions. The 3 petitions are not going to suffer any prejudice as their cases can be considered for the remaining 5 vacancies. This is your case, sum and substance. First of in such view of the matter, the objection raised by Mr. Mojumdar appears to have some force. First, Ms. So-and-so, Learned Counsel, has submitted that she is being led by Mr. Kain Chaudhary, Learned Senior Counsel, who has some personal difficulty to appear in the cases this week. First, she has beseeched to list the cases on 2nd of December, 3rd of December,
3rd of December.
2025. Post op. As a last opportunity. Post op. In view of the court has already observed in the order
28/10/25.
dated 28/10/2025 that all these matters will be taken up for admission hearing. Full stop. And in the above view of the matter, the prayer made on behalf of the petitioners, do accepted, with a caveat that no further opportunity for adjournment will be granted on 3/12/2025. His
Interim order, my lord.
out of it.
Yes, madam.
My lord,
Okay.
my lord, interim order passed earlier.
The interim orders passed earlier shall continue till the next set of district.
My lord, one observation may kindly be made, madam. In the event the whole matter cannot be taken up, this IA 21855 by them may be kindly taken up for consent. This 218 where
It is
we
further
have
observed
again,
that in the event the cases could not be taken up for final consideration, an endeavor will be made would be made for consideration of, for final consideration of the interlocutory application I number
218 of 25.
2025. Full stop. Or Mr. R. Swakia.
Somewhere your lordship has dictated that if the DPC is allowed to take a decision. DPC has been allowed to take a decision, but no final result is.
Okay.
So if the result is not, if the result is declared in the.
If the result is declared.
Yes, if the result of DPC.
DPC of the already convened, the decision of the DPC
is
already convened.
Yes.
Is allowed to be declared from a subject to the outcome of the petition. The petitioners are not going, three petitions are not going to suffer any prejudice. That is, you complete the line. You have no objection if he's.
No.
Mr. R. Swakia, Learned Counsel for the petitioners. In WBC number 459, 2022 has submitted that the subject matter of the petition is different from the other 4 petitions.
My lord, I'll be objective to that, my lord, because my friend also, my lord, they'll be harping on me. My lord, that committee recommendation, my lord. By the way, my lord.
Here, madam, my let us keep it that only till third of this.
Third, my lord, let's keep it together, my lord.
Then again, you will come again in the batch. You get dealing yourself on 3rd of December.
Correct.
Mr.
My lord, because my lord, I am seeking an early hearing, my lord. My lord, because my lord, I am seeking an early hearing.
Early hearing on 3rd.
My lord,
It's already early.
already in order, my lord.
Already early. You submit, get yourself dealing.
Because my lord,
We are not going in deeper into it. As Mr. Additional AG has objected to it, let us be on 3rd of December.
Obliged.
Okay.
Item number 10.
Yeah, please, your lordship, this matter pertains to recovery of excess pay from a retired employee, lordship, in contrary to the rule 6 sub-rule 2 of the lordship Central Civil Service revision of payroll 2016. And in this regard, lordship, the affidavit of the respondent authority is very much required because, lordship, the entire lordship process has been done in contrary to the lordship ruling laid down in the Rafiq Masjid case, lordship, which is not permissible, in fact, to recover from
File affidavit or not?
Not yet filed, lordship.
Fine. Yes, I have filed already.
1811. Yes. Please give me one copy because whom you have.
No, without serving them, we don't file, Lord. We are not allowed to file also.
Whom you have, sir?
Affidavit in opposition is filed as per number 2.
It may be
1811.
It may be received to my clerk. I will receive it, and I may be allowed to go.
Workers clerk must have received it, Lordship.
Get a copy.
Lordship. In the meantime, Lordship will file the affidavit on behalf of respondent number Lordship 3 also.
You have filed?
We'll file, Lordship.
Okay, how much
In the
time
meantime.
you need?
Lordship, 2 weeks.
Okay.
Lordship,
We are
date
in
may be
receipt
on
of my instruction, Lordship.
respondent number 3 is executive engineer.
Lordship, in that case, for now, 3 weeks time, Lordship.
Whom we have served the copy because
Usually it is
I'm
sent
only
to the Bagra. Usually.
Then it's okay.
Art Mr. D. Sharma, Learned Counsel for the petitioner, and Ms. K. Wangmo,
No, Lordship, G at the MSG at the.
the Learned Counsel for State Council. For the all the respondents.
Yes, Lordship, for all the respondents.
Post of. Ms. Ete has submitted that an affidavit in opposition on behalf of the respondent number 2 has already been filed, and
10.
you need
70.
2 weeks time to file an affidavit on behalf of the respondent number 3. Post of. Ms. Ete has thus paid for listing of the case after 2 weeks. Post of. Mr. Sharma. Okay. List the case on after 2 weeks. Give it.
Lordship, liberty may be given to file reply if
The petition in the petition list the case on so and so.
If
The
necessary,
petitioner may file its affidavit in reply if so advised.
Lordship, if necessary, I may be allowed to file additional affidavit also.
In the meantime, reply. Why additional affidavit? You make a reply. Why additional affidavit?
Lordship,
Why is the provision for filing additional affidavit?
okay, Lordship.
Don't make it installment. Next.
I have list.
Give it
Yes, 1511
1512.
or 1512, sorry. Item number 16.
16. 16. Yes.
We have come before this court, your lordship, against the order of suspension dated 11/7/2025. In this order, your lordship, certain disciplinary proceeding was contemplated and then the order was passed, your lordship. In the meantime, more than 4 months has passed. Again, on 13/10, your lordship, it has been extended by the review committee. And that is against the provisions of law, your honor. No.
Why is the initial suspension order?
Page 79, your lordship. Initially, yes. Page 87, annexure 19.
Yes, contemplating.
Disciplinary proceeding.
Yes.
Then on 1/9/2025, in my affidavit, additional affidavit, we have annexed the display the articles of charge, your lordship.
Additional affidavit or affidavit
Yes.
in reply.
Affidavit in reply.
One.
Four. Annexure. Page 134 to 140, annexure 21, your lordship. Now the
Take your seat. Yes.
Now the allegation against the petitioner is this, that he had appointed 3 extra laborers
No, when the article of charge
on
was
1/9/2025, lordship. Page 134, annexure 21. In the affidavit in reply, your lordship.
so this was within 3 months.
Yes, more than 3 months. Yeah.
Huh?
Yes, within 3 months it was.
Within 3 months.
Yes. Then they have reviewed the suspension order, Your Lordship, on 13/10/2025. That is in contravention of the law, Your Lordship.
Where is the order?
That is annexure
161.
160 page, annexure 23, Your Lordship. Original is another.
160.
Annexure 23, Your Lordship. उसको दे दो देगा वो।
Yes.
Now, this order, just I'll read. Whereas Sri Niranjan Kumar Jha, Executive Engineer, Daporoji Electric Division, Dharavai, was placed under suspension by government order number so and so 15 July, they have mentioned here. Whereas this order was passed on 11th of July, Your Lordship. The original order with immediate effect, as it is mentioned in page 87, annexure 19, Your Lordship. So as per annexure 19, page 87, the review should have taken place before 8th of October 2025, within 90 days as required under the law.
No, finally, page 87, as per the memo, it is 15 July.
Yes, they have said it, but as per annexure 19, it was on 11th of July with immediate effect. And this particular provision of law has been interpreted by the Honorable Supreme Court as well as the Honorable Delhi High Court recently, Your Lordship.
87, page 87.
Yes, page 87.
This is an order passed by the Chief Secretary.
Yes.
And under the Secretary power, under memo number so-and-so dated 15 July 2025, that has been addressed to you,
Yes, Your Lordship.
right?
Yes.
Then this is 15 July.
That is 15 July on.
Then memorandum of charges were framed, served upon you in
1st September.
1st September. Okay, within 90 days.
Yes, within 90 days.
Within 90 days. Then this review order is passed on which date?
On 13th of October, they mentioned.
13th of October.
Yes.
Yes. Now, according to you, it is 11 July. The
Yes.
period is to be counted.
Yes, Your Lordship.
Okay.
Now, I'll just rely upon two judgments of the Honorable Supreme Court as well as Delhi High Court. In serial number 2, Union of India and others versus Syed Sajid Ali. It is a division bench judgment pronounced on 24/2/2025, Your Lordship. Relevant paragraphs 13, 14, 15, and 18. Just I'll refer para 10 here. We are unable to accept the said submission for the simple reason that the order of suspension itself states that it was being issued with immediate effect. Similarly, in our case, Your Lordship. Then para 13, in the present case, however, the review committee which set to consider the question of extension of the respondent suspension itself met on 14 January 2013. The order of suspension was passed on 15 January 2013. Rule 10, 6 and 7 of the CCA rules are clear in their mandate that an order of extension would automatically come to an end on the expiry of 6 months from the effective date of suspension unless it was extended prior thereto. No order of extension of suspension having been made prior to 3-4 January 2013, the first extension of the respondent suspension as well as all subsequent extensions of the respondent suspension were rendered illegal. The tribunal is therefore correct in the view it took. Then para 18, accordingly, your lordship, this was counted from the date it took immediate effect from that, not the date on which it was communicated, your lordship. Similarly here,
Similar situation arose there.
yes, it arose there.
Similar situation arose there.
Yes, in that second judgment, it has been clarified, your lordship. The judgment which has been delayed, 2009 judgment of the Honorable Supreme Court. That is paragraph 10 and 11, your lordship.
2009 judgment?
Yes, it is.
Which you are,
Serial number. Yeah.
which one you are reading?
Serial number 4, Union of India and others versus Deepak Mali, which has been referred, para 8, 10 and 11.
Para.
Yes, Deepak Mali. Yes. The same point was considered by the Honorable Supreme Court.
Which Deepak Mali?
Union of India and others versus Deepak Mali decided on December 15, 2009. Paragraph 10, 11. May I read?
The law is settled so far as Ajay Chaudhary, Deepak Mali, all these are concerned.
Yes,
The
Lord.
question here is that though in the order of the Chief Secretary, it says that with immediate effect.
Yes.
Now, when in a matter of suspension, when it takes effect, because the order is also there.
Yes, it is.
Second part of the order, that the order has been issued. Order has been issued.
Yes.
To you.
On 15th.
By the Secretary on 15.
Yes, your Lord.
If 15 is the date, suppose as the respondent would condemn, right?
Yes, your Lordship.
Then the preparation of the memo of charge and supply of the memo of charge, as well as the order of review,
yes, your Lord.
is within time, right? And if it is to take effect from 11th of July, then it is beyond time.
Yes. So
as simple as it.
Yes. So we may.
Now we have to address on though in the order it is there the suspension with immediate effect when it took effect.
So that has
because till that point of time or up to 15th of July, the order was confined inside the file.
Yes, your Lordship. That has been clarified in these two judgments, your Lordship.
Which one?
Now, para 10 and 11.
Para 10 of which one?
Now it says, your Lordship.
Which one? Please name the judgment.
Same judgment, Deepak Mali judgment. Just which I have just referred. Union of India versus Deepak Mali, page 224.
No, you have not paginated, though it is very difficult.
Serial number 4, your Lordship.
Serial number 4 is okay. Finding out the judgment, you have not paginated. Had you paginated it, it would have been easier for us. Let us see the facts.
Yes. Of this case, Your Lordship,
Para 2, Deepak Malik.
under Rule 10 of the CCS Rules 1965, amended by notification dated 23/12/2003, sub-rule 6 and 7 were inserted. As the same are relevant to the facts of this case, the same are extracted herein below. An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority competent to modify or revoke the suspension before the expiry of 90 days from the date of order of suspension, on the recommendation of the review committee constituted for the purpose, and pass orders either extending or revoking the suspension. Subsequent review shall be made before the expiry of the extended period of suspension. Extension of suspension shall not be for a period exceeding 180 days at a time. Rule 7, notwithstanding anything contained in sub-rule 5, an order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid after a period of 90 days unless it is extended after review for a further period before the expiry of 90 days. The aforesaid amendment came into effect from 2/6/2004, but as a review committee was not constituted, the respondent's suspension was not reviewed as required by the amended rules. The respondent therefore claimed that the suspension order must be deemed to have been lapsed, and accordingly, he approached the Central Administrative Tribunal by filing OA number so-and-so for a declaration that the suspension order dated 10/8/2002 became invalid on the expiry of 90 days from the date on which sub-rule 6 and 7 of Rule 10 came into force, since the same had not been extended by the review committee. There is no dispute that the suspension of the respondent was not extended. The tribunal accordingly allowed the application filed by the respondent, and by its order dated 29/3/2005 was the suspension order dated 10/8/2002.
So there it was not extended.
Yes, there it was not.
Now let us have paragraph 10 and 11 again.
Yes, Your Lordship. Having carefully considered the submissions made on behalf of the parties, and having also considered the relevant dates relating to suspension of the respondent, and when the petitioner's case came up for review on 2010/2004.
They said that it was not extended.
Suspension of the respondent, and when the petitioner.
Something more, there are more facts then. Because it says it came up for review on
2010/2004.
Some more facts then.
Yes, Your Lordship. Para 7. On behalf of the Union of India, it was not denied that the appended provision of Rule 10 came into effect from 2/6/2004, and the case of the respondent was reviewed on 2010/2004 beyond the period envisaged under sub-rule 6 thereof. It was, however, contended that the delay in conducting the review was not on account of any leakage on the part of the petitioners, but having regard to the fact that the respondent filed OA number 540/2004 before the Central Administrative Tribunal in July 2004, and the same was disposed of by the tribunal on 18/8/2004, during which period the petitioner was unable to take any action under Rule 10 in view of the provisions of Section 19(4) of the Administrative Tribunal Act, which provided that where an application has been admitted by a tribunal under subsection 3, every proceeding under the relevant service rules as to redressal of grievances in relation to the subject matter of such application pending immediately before such admission shall abate, and save as otherwise provided by the tribunal, no appeal or revision in relation to such matter shall thereafter be entertained under such rules. It was submitted that since the proceedings were pending before the tribunal, the petitioners had no option but to stay their hands in regard to the proceedings against the respondent. It was also submitted that on 2010/2004, when the review committee took up the petitioner's case, it extended the period of suspension, which was again extended thereafter by order dated 8/4/2005. The learned counsel for the petitioner submitted that, having regard to the above, the order passed by the High Court upholding the order of the Central Administrative Tribunal was liable to be set aside, along with the order passed by the learned tribunal. On behalf of the respondent, it was urged that Section 19.
Okay. I have read. Yes.
Now, para 10 and 11 will be read.
I have read.
Now, everywhere in those two paragraphs, the Honorable Supreme Court has said the immediate on the date when the order was passed, Your Lordship.
Right. Normally, we have seen many orders.
Sir.
We have dealt with many orders of suspension, but not like this order at page 87.
87.
We have dealt with many suspension order. We have set aside many extension, but we have not come across this kind of order at page 87.
Lordship.
Now, suspension takes effect immediately, right? It is always there. Any order is to take effect immediately.
Yes.
But question is that the date of communication, whether it has any significance.
If that is taken into consideration,
The
Lordship,
fact of the matter is whether on 11, 12, 13 and 14, you were in service or not.
on 11/7,
11, 12, 13 and 14.
11, 12.
13 and 14 of July 2025.
Lordship, 11/12, I was not.
11 July,
11 July, I
12
was.
July, 13 July, 14 July. Because as per this order is passed under the hand of the secretary
Hmm?
power on 15/7. On
Yes.
15/7.
On 15/7,
Whether date of communication has any significance or not. Many orders can be passed inside the file,
Lordship.
but it takes effect normally on the date of communication.
But
And yes, if it is by arrest, it may have retrospective effect as soon as you spend 48 hours in custody. Right? But order can be passed later on. Now that is my question.
now,
Case of suspension, anything distinguishing?
that has been
Anything distinguishing?
clarified in the High Court judgment, Delhi High Court judgment, Your Lordship.
No, I have seen.
Now,
Delhi High Court
if
judgment also.
then there is one more
Yeah,
judgment.
I have seen. That if you refer to Syed Sajid Ali,
Yes,
it is only that under suspension with immediate effect.
yes, immediate
Right.
effect.
But there is no such memo as like page 87.
Yes, in that case, it may be not there.
I mean, not
Now, then we have to read page 160, Your Lordship.
116.
Yeah, that is the in reply what they have said while extending it
Yeah.
on 13th October. Now it is dated 21st October.
Which one?
Page 160 extension of the suspension order. Now, if we take into account 15th of July when it was communicated, then here it is 21st October 25, Your Lordship. And extra 23, page 160. The order of extension of suspension, Your Lordship.
Page
160 and extra 23,
160.
yes,
One,
affidavit in reply.
160. One,
160 and extra 23.
what is 160?
Affidavit in reply by the petitioner. 160 and 161 is the typed copy.
161
Is the typed copy.
type copy. You want to say? Okay, your case is that if that is taken,
Yes. So 21st October.
October is beyond time.
Yes.
That is what your case. Now where Supreme Court has
Now, if we take into consideration
which judgment?
Deepak Mali Para 11, Your Lordship. which has been relied on by the Honorable Delhi High Court. There are 11, may I read, Your Lordship? The case sought to be made out on behalf of the Petitioner Union of India as to the cause of delay in reviewing the respondent's case is not very convincing. Section 19(4) of the Administrative Tribunals Act 1985 it speaks of abatement of proceedings once an original application under the said act was admitted. In this case, what is important is that by operation of sub-rule 6 of Rule 10 of the 1965 rules, the order of suspension would not survive after the period of 90 days unless it was extended after review. Since admittedly the review had not been conducted within 90 days from the date of suspension, this is from the date of suspension, Your Lordship. It became invalid after 90 days since neither was there any review nor extension within the said period of 90 days. Subsequent review and extension, in our view, could not revive the order which had already become invalid after the expiry of 90 days from the date of suspension.
What are these pleadings? This is this is in connection with this case.
Today, respondent number 5 has filed an affidavit, Your Lordship. We have received copy today in the afternoon.
Who is respondent number 5?
The private respondent.
Private respondent.
Yes.
What he has to do with suspension order of the petitioner?
Because he is in charge of the post.
That is in charge.
And then there are some allegations against respondent number 5.
We are not into allegations and all, correctness of the allegation.
Yes.
Two copies means two copies. Two copies, same evidence.
Yes, same.
Okay. Yes, what is the stand, Mr.?
But before going into the merits, my lord, writ petition initially is being filed, my lord, challenging the very suspension at page 87, suspension order. The writ petition is only for setting aside this suspension order.
Is it?
Yes, my lord. Now, by virtue of a reply affidavit in reply, they have brought in the review.
A Lordship.
Extension of suspension. Now, they are seeking to set aside that order without challenging that.
If that was not under challenge, then their affidavit is on a different ground.
Yes.
If your initial page 24 now, your challenge is to 11/7/2025.
Your Lordship.
And contemplating
Disciplinary proceeding. Yes, Your Lordship.
That power is always there.
Yes.
Under the rules.
Yes.
In contemplation of
Yes.
disciplinary proceeding. And specific challenge was to that order.
Yes, that was this.
Now, this was by as a corollary by affidavit in reply, you were making these submissions. Because if you are to want to challenge this, you should have mounted an independent challenge. Because the challenge is 11/7/2025.
Yes, Your Lordship.
They are defending that order.
Yes, they are defending that.
They are defending that order.
Yes.
Now, in your affidavit in reply, you have brought in this fact.
Yes, Your Lordship.
We should have challenged it independently.
Yes.
This is not the way normal writ proceedings follow. Because para 24 is very clear. Page 24. Your pair.
Yes, 11/7 we have challenged. So you may be allowed to file a IA, Your Lordship, in this case. By way of amendment, we shall bring, because these are the subsequent developments which has taken place in this case.
Now, IA and all, because this has rightly or wrongly merged into the subsequent order.
Yes.
But according to you, it has not merged. That order of extension is beyond time.
Yes, Your Lordship.
So there should be an independent challenge to it. This order of extension,
Lordship.
according to you, is beyond time and in
Yes.
violation of Rule 10.6, 10.7.
Exactly, Your Lordship.
Deepak Mali,
Yes,
right?
yes, Your Lordship.
So it should be an independent challenge because this has gone.
We
We
may-
have spent its
No,
force.
we may amend this writ, Your Lordship, because without the initial order, this order will not exist. If the initial order does not exist, this order will not exist, Your Lordship.
It is up to you.
Yes, so I may be allowed.
Amendment, they will seek 4 weeks time.
Allow-
Same thing, you'll be into more difficulties.
Yes, I guess,
Okay, it is up to you. Okay, you seek amendment. You file amended petition. Then amended petition means all these paras are to be changed. You have to seek leave for amending these paras, adding these paras, correction of these paras, then amended petition. First, that has to be allowed.
yes,
That
Your Lordship.
amend-
That I understand.
Then thereafter, you have to file amended
Yes,
petition.
yes, yes.
Thereafter, notice will be issued.
So it may
It
be
is up
fixed
to
on
you.
second, I will take instruction from my client. Your
It is
Lordship.
up to you.
On second, it may be fixed, Your Lordship.
On the prayer of, otherwise, setting aside an order, which is not challenged.
That I understand, Your Lordship.
Mr.
Yeah, yeah, he has rightly pointed out.
Your name,
I am Biswajit Prasad.
B. Prasad, Learned Counsel for the petitioner, and Mr.
N. Ratan.
N. Ratan, Learned State Counsel. For the learned, you are
Additional AG.
Additional Advocate General, AP, for the state respondent, and Mr. PK Ghosh, Gaur, Learned Counsel for respondent number 5. First of all, Mr. Prasad, Learned Counsel for the petition, has submitted that in view of subsequent developments in the form of a review order dated 13/10/2025, which was issued on 21/10/2025. The petitioner would need some time. He would need some time to for further instruction, complete his instruction. First of, as sought for by Mr. Prasad and as agreed to by the Learned Counsel for the respondents, list the case on 2nd.
2nd of December, Your Lordship. Obliged. Very good, Your Lordship.
The affidavit in opposition of the respondent number 5 is to be indexed by the registry. Is to be indexed by the registry. Is to be incorporated in the index by the registry.
Obliged, Your Lordship. Good day, Your Lordship.
Item number 17.
Yes.
Yes, Your Lordship. Lordship, this matter pertains to non-payment of contextual bills, my lord. On
This
bill.
is the first date. Yes.
No, not the
instruction.
first day. They were supposed to place the instruction, my lord. Standing counsel for the RWD
No,
department.
the returnable date.
Yes, my lord.
Yes.
No,
Z Tarak.
give me Tarak, sir. It's not there.
G Tarak.
Yes,
He is not present.
not present.
When Mr. Mozumdar is coming in?
My lord, can you be fixed on 11th?
When the Arak is
Yes, yes.
11.
Yes, 10 and 11 both are there. 2 dates are there, my lord.
Mr. P. Bora, Learned Counsel for the petitioner is present. Where is the Learned? Where is Mr. Z Tarak, Learned Standing Counsel, RWD Department for the respondents is found absent today on call. Post of. Let the case come for answer of justice, be listed again on 11/12/2000.
My lord. Bless.
Item number 2021.
2021. Yes, Mr. Counsel.
Lordship, I'm
Why
referring,
come for orders? Summary copies of it have not been.
No,
filed in
Lordship,
supplementary application.
if I may please, Lordship, we are the petitioner here. Lordship, we had filed this IA for praying for injunction against the illegal cutting done by the private respondents, Lordship.
Illegal cutting done.
I mean, they are cutting trees while there is a dispute matter pending before the Honorable High Court, Lordship, that's why.
Right, but whether there was any interim stay order?
No, Lordship.
No stay order.
No,
No,
Lordship.
sir.
So you are renewing your prayer
Yes, Lordship.
by this IA.
Yes, Lordship.
Initially, there was a prayer in the repetition.
No, there was no prayer,
No
Lordship.
prayer, Lordship.
No prayer, Lordship.
No prayer.
No prayer.
Whether pleadings, file, repetition.
Therefore, Lordship, I need to file objection, Lordship.
Oh.
No,
You are for
Lordship,
I'm for private
opposite
respondent.
party?
Private respondent number 3 to 10.
So he is alleging that you are cutting the trees.
Yes.
yes, Lordship.
8 to?
3 to 10.
3 to 10.
Okay, allegations are against you.
Yes, Lordship.
You are my
State respondent.
state. Okay, at least one opportunity more given.
Yes, Lordship.
Lordship,
sir.
they have been, this cutting has been going on for more than 2 years,
How
Lordship.
can we verify, sir? You can make any allegation, but
Exactly,
state will say. Take your instruction also.
Yes.
In the eye. In the eye. Affidavits are filed already.
Filed by the
So in the main case, Lordship.
ADC,
Ah,
ADC, not by the private respondents, Lordship.
file, not file.
Not
No,
filed, Lordship.
not filed.
Why don't you file?
Yes, and it's been more than 2 years, almost 2 years, Lordship.
No, Lordship.
You file.
Yes,
In the mean
Lordship.
also.
2 weeks time may be given. In I also, Lordship, I'll file objection.
Both 2 weeks then.
Lordship, our contention here is that they have been allowed to cut trees in the disputed land, while we have not been able. We have not been allowed to. That's our main contention. This is
They are not challenging the ownership,
Both
Lordship.
are doubtful, sir. I have seen.
Yes,
Both are of doubtful credentials. Right, I have
All right.
seen. That is why court consciously did not give anything, observe anything. Simply,
Lordship, in their main writ petition, Lordship, they are not challenging any ownership, Lordship.
we are
So,
challenging.
Lordship, illegal cutting does not arise here.
It does.
what is the stand of the state respondent? Heard Mr. Doku,
E-buying, Lordship.
Paying,
Yes.
counsel for the applicant read petitioner. Miss
P. Sangeeta.
Learned State Council,
Yes,
Government
I am
Advocate, for the opposite party, that's respond number 1 and
One.
2. And Mr.
K. Loyal.
Loyal Learned Counsel for the opposite party, that's respond number 3 to 10. First up. Mr. Lawyer has sought for and is granted 2 weeks time to file an objection to the instant interlocutory application. First up. I'll list the case on this. Same in the WBC. Remove the opposite parties. Mr. Lawyer, same. 2 weeks. List the case on.
Lordship,
2 weeks.
Lordship, I have one.
Bring it in.
It's been more than 1.5 years, if that is on
Bring
record.
it in.
10, 12.
Okay.
10, 12. Okay.
The affidavit of the counter affidavit of the the respond number 3 to 10 shall ensure that its affidavit is filed on a before and next counter affidavit in the WBC.
Deeply obliged.
Highly obliged.
Item number 22 and 23.
May please, ma'am. My lord, here, I am the respondent in the writ petition, but I have filed an IA.
Yes.
That's for vacation of the interim order dated 5/9/2025. Pass in the writ petition.
Pass in the read.
Yes, ma'am.
Who is the petitioner? Yes.
I'm for the petitioner in this writ petition, my lord. And this writ petition, in this earlier order, this honorable court was pleased to pass an interim order dated 5/9/2025, and which the order was directing the respondent company not to give effect to the impugned office order that was dated in 11/7/2025, whereby the petitioner and the others
Now,
similarly situated.
Are you ready to for this IA?
My lord, that may be fixed for filing.
Not ready today.
Not today, but I want to tell about my stand today here.
No,
The respondent company is
if
not.
you're ready with this, they're not required to make your stand clear. You can hear this.
It can be heard, my
We'll file a reply on the next date, my lord.
Why? Oh, today is the first date or what?
just, otherwise today is the second day. In fact, on the last date,
Wait for time. You are Miss Terry.
S. Medhi, my lord.
S. Methi.
My lord.
On the previous date, time was sought for respondents.
Yes,
Yes.
my lord, I was engaged in some other case in the principal seat at Guwahati.
So on your behalf, time was sought.
Yes, my lord.
So
my lord, the difficulty that has arisen, my lord, is that just a brief facts, my lord, that this company, my lord, is a PSU, my lord. It's an
so
understanding,
your promotion has been stalled.
my lord.
Is
That,
it not?
that was
It has been, you have been downgraded.
no. I'm for the company, my lord.
Huh?
I'm for the company.
petitioner, my lord.
I'm
You are
for
for a company.
Yes, ma'am.
Huh.
Now the situation is arisen where, my lord, in fact, after the filing of this IA for vacation, subsequent development has taken place, and now the company is supposed to wrap up its operation and hand over the this assignment to the NHPC, my lord. Now all the staff will go back, my lord.
And that is a different
So,
matter, but this
yes, ma'am.
petition, they have a case.
My lord, that's why, my lord,
They have a case.
my lord,
This petitioner has a case.
My lord,
that I would beg to differ, my lord.
Okay, then your IA, let us have your, in the context of the facts.
My
We
lord.
can take up your IA.
my lord,
That-
The facts pleaded in the writ petition will be taken up for consideration.
That can be, my lord.
Huh?
If my
my most humble submission is that, my lord, very tactfully the respondent company transferred me
Okay.
to another plant, BTPP at Buxar,
Okay.
Bihar, where I was demoted, my lord.
Okay.
The respondent company did not
How much
comply
time you
with,
need then
my lord,
to file your response?
maybe 6 weeks.
IA, 6 weeks. By that time, company will be closed.
And 4 weeks
Your writ
minimum.
petition will become infructuous. You'll be out of the job.
Yes, that is also my lord true.
by that
Okay,
time we
Okay,
will go
take
back.
this. Heard, Mr. So-and-so learned counsel for the applicant. Respond number?
I'm in the IA, I'm the applicant, my lord, and otherwise in the writ petition, I'm responding 4 to 9, my lord.
Respond number 4 to 9 and Miss S. Methi.
As Medhi, my lord,
Learned
for the
counsel for
petition.
the opposite party to has writ petition of post of Ms. Methi has sought for and is granted 10 days time to file a written objection to the instant interlocutory application seeking vacation of the interim order dated
5/9/2025.
5/9/2025. Post of list the case on give it after 10 days.
My lord, we have also filed
The
an
interim
additional
order passed
affidavit.
earlier shall continue in the meantime.
We have also filed an additional affidavit in the next,
It will
last,
not on record.
Any date?
8/12.
Sorry? 8.
8/12.
Can it, 9th, my lord?
Can it be in the second week of December?
Second week, it's second week.
Itself is second week.
Yes.
8
Nine-
to 12. You choose a date. Next.
May I pray for 9th, my lord? 9th, 12th, my lord. Second week. 9th.
I may have some other 9th of December. Okay, fine.
9 December.
Yes, my lord. Wait.
9th.
Obliged.
Highly obliged, my lord.
Item number 24.
My lord, in this case, my lord, I received the copy of IA just day before yesterday, so I may be allowed, my lord, 3 days time to file objection, my lord, on the IA.
In the IA.
Yes.
Lordship,
3 days is
I-
very reasonable.
I pray for disposal of the writ petition itself, Lordship, because urgency is there, Lordship. Examination is scheduled on 7th of next month, Lordship.
7th of
December,
December.
Lordship. And
7th of December.
yes,
Yes.
interim order is there, Lordship. And examination is common examination, Lordship.
My lord,
Because
only 3
in
days
IA
time may be granted.
IA is for what?
For vacations of the interim order.
Vacation.
No,
Okay, we'll take up the writ petition if the pleading is complete.
Pleading is complete.
no, my lord,
Day after tomorrow. If the pleading is complete,
yes.
we can take up.
Lordship.
My lord,
tomorrow.
Day after
then, my lord, today we have filed one contempt petition which is connected with this petition, my lord. So, my lord,
Filing
this may
contempt
be,
also.
yes, this may be listed as another
List
matter.
this writ petition,
Day after-
IA and contempt petition number so and so
Yes, my lord.
on day after tomorrow.
Tomorrow.
26.
Lordship.
Obliged.
Obliged.
And then never will be made to give, to take up the writ petition and other cases on the next set of list.
Lordship. Obliged.
Obliged.
Item number 25.
Yes, for what?
Service-
Notice
Yes, service is incomplete. Awaited.
many
Mean.
P. Bora petitioners, Miss so-and-so, Lawyer State Council. There is the office note dated 21/11/2025. Post of as per the office note, service reports. In view of the office note, I wait for the service reports in respect to respond number, likhi dibo. Release the case after 2 weeks.
3 weeks, your lordship. I have to
3
file affidavit also.
Okay. Ms. So-and-so, Lawyer State Council has paid for and is granted 3 weeks time to file counter affidavit on behalf of the state respondents. Release the case after 3 weeks for service reports as well as for filing of counter affidavit by the state respondents.
Okay.
Any interim order?
No.
No.
No. No.
No.
Interim.
Okay.
Item number 26.
My lord, and item number 26, I have received the affidavit in opposition, my lord. I need some time to file my rejoinder, my lord.
Mr. P. Bora, Learned Counsel, appearing for the petitioner has sought for and is granted how much time?
3 weeks.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the state respondents.
My lord.
Mr. Roton, Learned Additional Advocate General for the state respondent is present full stop. Release the case after 3 weeks. The interim order,
There's no.
No, there's no.
order. Okay. In view of the office note dated 21/11/2025, I wait for the service report in respect of respondent number 5.
Oh.
6.
Item number 27 is also same, my lord. Same
Let us have,
petitioner.
let us have.
Same order.
Same.
Affidavit file,
My lord.
affidavit in reply.
I need to file evidence.
You need to file. Okay, 3 weeks. Office note dated 21/10/2025. I wait for the service report in respect of respondent number 5.
Item number 28.
The service upon the private respondents are awaited. B. Kaushik for the petitioners. And Mr.
B. Picha.
Learned Standing Counsel.
Yes, ma'am.
Which one?
For respond number 1 to 5, he will be.
1 to 5. Are present. Full stop. Here is the office note dated 21/11/2025. So they wait for. You have filed your affidavit.
No, my lord.
My lord,
Would you file?
yes, ma'am.
Okay. Mr. So-and-so, how much time?
11th.
So
They are seeking 11th.
Huh?
11th, 12th. 11th of this.
would you be able to file?
Yes, ma'am.
Okay.
I have sought Paravas command.
Okay.
In
Has
fact, our
sought for,
reply has already been received by us also and them also, my lord.
has sought for and is granted 2 weeks time to file counter affidavit on behalf of the respondent number 1 to 5. Full stop. There is the office note dated 21/11/2025. Await for the service reports in respect of respondent number 6, 7, and 9.
My lord,
Release
may
the
I-
case on 11.
Ma'am,
11.
my lord, registry may be directed to reflect my name, my lord.
The So I
I could not
bring my record is to be reflected in the response side in the cause list.
Yes.
Interim order may be continued.
Interim order passed, you shall continue till the next.
Published.
Item number 29.
29 also, my lord, the office note dated 21/11. The service is awaited upon the private respondent.
All private respondents.
Yes, my lord.
You are 1 to 5.
Yes, we will carry.
1 to 5. By Hineke. Await 6, 7, and 8.
6, 7, and 8.
Interim order.
Item number 30.
Same 2 weeks time. to
Same,
file.
same order.
11.
Yes, my lord.
Same. Service report
Upon here, my lord, the respondent number.
silo, office note silo. Office note silo, respondent number keda silo. Interim order.
Yes, my lord.
Okay, 2 weeks time.
Registry.
2 weeks time. 1 to 5.
And registry, yes.
Registry to reflect.
Because I could not bring my file there.
Okay, registry to reflect.
Yes. Obliged.
All are fixed on 11.
11th. Great.
Item number 31.
Miss
And Duncan.
Council petition is present.
Lordship, I was allowed to take steps upon respondent number 5 and 6 through email also, which I have done on 12th of November. I filed an affidavit also to that effect.
Please use the office note dated 21/11/2020. You are Miss
P. Pahu, Your Lordship.
Learned State Council for the respondent number
1 to
Government
4.
Council. Here's the office note dated 21/11/2025. So stop await for the service report in respect of respondent 5 and 6.
Lordship, that would be in respect of the service, the steps taken upon the respondents through registered AD. But I have taken steps via email also. For that, I have filed an affidavit also. It was received by them on 12th.
Oh, whereby it was, you were allowed?
By the last order, Lordship, order dated 11/11/25. Because, Lordship, this, I was pressing for an interim.
1 minute.
Yes. 11/11. In my,
1 minute, 1 minute.
Lordship,
1 minute.
sorry.
What was by the order?
Lordship,
What was by the order? Serious order email?
upon service of notice,
If that be so,
Yes.
the court is inclined to permit
yes,
the learned counsel for the petitioners
yes.
to first
That also I have done,
bring
Lordship.
on record. Where
Yes.
is that?
Lordship, it will be in the records, Lordship. And
It is not reflected.
post title, Lordship.
Post title.
Yes.
Respondent number 5 and 6.
Yes, I have added the email address of respondent number 5 and 6. That would be at page 8 and 9. Bottom of the page, and page 9.
Is there no standing counsel for NHIDCL?
I'm not aware of, Lordship.
Huh?
I'm not aware of.
In internal governments?
At least I'm not aware of it, Lordship. I don't know.
No, they have a number of standing councils in principalship. That is why
Yes.
they used to appoint. Yes, any idea? NHIDCL?
No.
No.
Since they have not appeared today, Lordship, next date may be fixed, maybe giving them just 1 week, because otherwise they should have
When did you
received
serve?
on 12.
By email?
12. The next
Copy
day
of the
itself.
writ petition.
Lordship, I file an affidavit, additional affidavit, that is page 137. 12 November, I have served. Page 137 and 138.
No content,
Lordship,
no content. Nothing about the subject matter.
Lordship, in the top, furnishing of writ petition number.
That court has permitted me my
Oh,
order dated.
No, Lordship, that was,
Then what is their business?
Lordship.
There should be the background.
Yes, I'm getting it, Lordship.
You have simply forwarded the copy of the writ petition without head and tail. How do you understand? It will not be proper service. You should have written that I have been permitted by the court,
Yes.
by order dated so and so, to serve a copy of the notice by email.
In that case, Lordship, I may be allowed
Let us
again.
have-
I will do it
have
within
a
a,
proper email.
yes, Lordship.
But so like,
I'll try to do it by tomorrow, Lordship.
So and so has submitted that the petitioner, in reference to the order dated
11/11.
11/11/2025, would send, would serve a copy of the petition along with annexes, giving the backdrop and reference of the order dated 11/11/2025 in its email, and would submit an affidavit thereafter. Lays the case sought for by Mr. So-and-so, lays the case after a week. For
Lordship, a big state, Lordship.
filing of an additional affidavit.
Lordship, can it be on fourth?
Shall we come or not?
Yes, more than that.
After.
Of late.
Item number 34.
Before that, we'll take up the admission matter.
My lord. In my case, my lord, some records may be required also, my lord. My lord, I am seeking parity with the drivers of my lord civil departments, my lord. I am a police driver, my lord. We are seeking parity of the my lord enhancement of the grade pay of the civil departments, my lord. They have enhanced the my lord the pay grade pay of the my lord civil drivers, my lord, in parity with the LDC, my lord, lower division clerk, my lord. And now, my lord, in our my lord case, yes, my lord. In our case now, they are saying that, my lord, the drivers of the police department and the civil department are not identical, my lord. But when they have drawn the my lord, the driver,
Civil and police.
yes, ma'am. They are saying that they are not identical, but they have drawn the analogy from the my lord, identical analogy from the my lord LDC and the civil drivers, my lord. Now they are not giving benefit to us, my lord. So, my lord, we file an additional affidavit seeking to produce that record, my lord, how they have drawn that parity between the lower division clerk and the drivers of civil police. If they can draw the parity between the LDC and the drivers, why not my LDC lower division clerks, my lord? LDA in Assam, it's a LDA, my lord.
Lower division clerk.
And enhance the, my lord.
Mr. Nair, no, I don't take up service matters in principal case.
Then, my lord, now they are
I
saying
don't
that, my
take up-
lord.
I am not given the roster for service matter for last 4-5 years. Right? So what is LDC? Lower division clerk.
Clerk, my lord.
Ah,
They have drawn the, my lord, parity in between, my lord, the
of department.
drivers of the department of Arunachal Pradesh, my
No,
lord.
no, these petitioners belong to which department?
Police department, my lord. Drivers.
Police department.
Yes,
They are working as what?
Drivers, my lord.
Drivers.
My lord.
Your police department drivers are seeking pay parity with drivers of
Other departments, civil department.
other departments.
Yes, my lord.
Okay.
Now they are saying that, my lord, the drivers of the, my lord, police department and the civil department, drivers of the civil department are not identical, my lord. That's why they are rejecting our case, my lord, for enhancing the grade pay, my lord. But they have arrived at the conclusion, my lord, that the similarity between the nature of, my lord, parity between the LDC and the civil police, my lord.
LDC and?
LDC and the civil drivers, my lord. While enhancing the, my lord, grade pay, my lord.
No, you are seeking parity with
the
drivers of other departments.
Other department,
right?
my lord. Yes, my lord.
Police department drivers.
Yes, my lord.
What is the relation of LDC and?
That's why, my lord.
What is
Now, that enhanced grade pay has been increased, my lord.
LDC and police driver?
Yes, my
Pay
lord.
parity.
Yes, my lord. In parity with the LDC, my lord, they have enhanced the, my lord, pay grades of the drivers of civil department, my lord. Now they are denying.
That is their statement.
Yes, my lord.
That is their statement.
Yes, my lord.
Where is that?
In, my lord. Let's see, my lord. Huh?
Madam, item number 7 may 3 or 7 may be taken up. Then we may be heard.
My lord, what I submit is that, my lord.
Because record may not be required.
That record may be required, my lord. That's why, my lord.
That we cannot. First, we have to hear it.
Yes. My lord.
This is calling for record just at the drop of a hat. May not be permissible.
Pass over matter, item number 3.
Yes.
My lord, petitioner is basically aggrieved by the action of the secretary, land management department. In my lord, cancelling the land position certificate issued in favor of the petitioner. My lord, while exercising his powers under appellate powers under a provision of the 2000 Land Settlement Act. Now these LPCs, in my humble understanding, are not issued under the Land Settlement Act.
What is LPC?
It's a land position certificate. My lord, in the state of Arunachal Pradesh, we don't have any statute governing, my lord, private lands. So it is only on the basis of an office memorandum, land position certificates are issued in respect of private lands.
Okay.
Only position certificate.
What is do you have any idea where is the governing office memorandum?
Office that I have brought on record in by way of an additional affidavit, my lord.
Additional affidavit?
Yes, ma'am.
First, let me have an idea about LPC.
Yes.
Additional affidavit by petitioner?
Yes, madam.
Any page number? Okay.
It is page number 19, madam.
Additional affidavit.
Type copies from page 21.
Or it is office memorandum dated 19/12/1988?
Yes, madam.
Okay.
Yes.
Page 19. Issue of possession certificate.
Yeah, possession certificate of owners of private land. Type copies at page 20.
Proper for issue of possession certificate to the owners of private land in various periods. Obtaining financial assistance from various institutions such as three. The government is decided to adopt the following procedure for issuing possession certificate in favor of landowner. Or desire to obtain they shall submit an application in form. The authority where the land is located. Following materials. Certificate compliance on using the
Actually, the whole problem would have been solved.
So some inquiry, basically
Yes.
it is on the strength of position,
Yes.
one becomes owner.
It is not even a ownership service, it's basically a possession service, it was basically issued for the purpose of obtaining financial.
Financial.
Yes,
So finally administrative authority, thereafter
Yes.
DC,
yes,
then obtaining approval from the government, he will issue
yes,
LPC.
yes.
This is the procedure.
That is the procedure.
Okay.
So, my lord, in 2000, my lord, the Arunachal Pradesh Land Settlement and Records Act 2000 came to be framed.
Mm.
Your lordship kindly have Arunachal Pradesh Code Volume 7.
Volume 7.
Volume
Yes.
7 at page 202, my lord, in my book.
202. Land settlement and records.
Yes, Records Act.
Yes.
Now, this act, my lord, is basically for, my lord, the government lands, my lord. It nowhere here also it provides for issuance of land possession certificates or any other certificate in respect of private land. Your lordship may kindly have section 5 or section 9, titles of lands, etc. at page 208. Nine one says, all lands, public roads, lands and paths and bridges, ditches, dikes and fences on or beside the same, the beds of rivers, streams, nalas, lakes and tanks and all canals and water courses, all standing and flowing water and rights in or over the same or appertaining thereto, which are not the property of any person or community, are hereby declared to be property of the government. Now, my lord, in our state, the tribal system is that tribes own these lands, my lord. As long as the lands are not acquired or, my lord, gifted, my lord, all are private lands belonging to the tribes. Then your lordship will kindly have section 12. So what the deputy commissioner can do? The deputy commissioner may allot land belonging to the government for agriculture purposes or for construction of dwelling houses, etc., etc. So that is what he can do. That is in respect of government land belonging to the government. Now, my lord, in exercise of powers conferred under this act, my lord, 2012 rules have been framed. There's a confusion in the department that they can issue the LPCs under it. That is why the confusion. They are referring to Rule 143 at page 21, madam. That is why the confusion.
143. 143 means?
Rule 143 at page 21, madam. Internal page 21. This is part 12, my lord will kindly note. Rights of landowners. 143. Issue of certificate. The deputy commissioner may grant a certificate in respect of each holding to a landowner, certificate of nature of his title, the revenue payable, and the area, giving such other particulars as he may consider necessary. Then my lord will kindly have 144. This has to be read together now. Terms and conditions regarding settlement of land held for purpose other than agriculture, the settlement of land under subsection 6 of section 88 shall be subject to the following terms and conditions. Now, if your lordship goes back to the Land Settlement Act, your lordship will find at section 88, it talks about, my lord, government land. So nowhere, either in the act or the rules, my lord, there's any provision for issuance of any certificate, my lord, in respect of a private land. Because we don't pay revenue also for in respect of private land holdings. 88.6 they have referred to at page 230. 88.6.
88.6.
Yes. 43, 142. Every person who at the commencement of this act holds land from the government for the purpose such and such shall be entitled to settlement. Land from the government.
So the land, you are in possession.
Yes.
You claim land ownership certificate.
Yes.
An inquiry is conducted.
Yes.
Ultimately, the issues a certificate, land possession certificate. What does it signify? That you are in possession?
They're only in possession, my lord. There's not a declaration of title.
That land belongs to whom? You are in possession.
Yeah, I
You
mean,
are not the owner.
basically, it's, not
But here
exactly
is
a
the
title.
In
Yes.
this office memorandum,
Yes.
it also there is mention of owner also. See,
Yes.
clause B, C, D. See, on completion of the above course of actions, if it is established without any doubt that the applicant concerned is the sole owner of the land.
Right. So it's basically a possession come, my lord, some sort of declaration of title also.
I don't know about the
Yes.
land law. That is
Yes.
why I am asking you. There is mentioned that sole owner of the land.
Yes, yes.
Government has been considering.
But these certificates are not backed by any statute.
Issue of possession certificate. No. See page 19. It's
Right.
the government has been considering to evolve a proper and simple procedure for issue of possession certificate.
Yes.
The owners of private. land.
Yes, yes. I'm sorry. Yes.
So ownership
Yes.
must be there.
Yes.
Second is possession.
Then, yes.
One can be a owner,
Yes.
but he may not be in possession.
My lord. Yes.
So possession certificate signifies both.
Yes.
He is owner as well as he is in possession.
Yes. Yes.
I think that is,
Yes, yes.
if that is if the ownership is there,
Yes.
how it is regulated, how it is decided by
My lord,
this.
no, my lord.
This is
As
not
far as private land is concerned, no.
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 What is the preamble to this act?
It says to regulate the my lord, land revenue.
Common land. Compared to deputy government land. Landowner is defined.
2L, my lord.
2L. Landowner is defined. Otherwise, if he is not the owner, he can go to a vacant place. I have the possession. Give me loan. A land possession certificate. I think ownership and possession both should go together to have a land possession certificate.
Yes.
2L, landowner is defined. If landowner is defined,
Yes.
then revenue must be payable.
No, my lord, we don't pay revenue, my lord.
Huh?
We don't pay revenue in respect of private land.
Is it?
Yes. That my learned additional advocate general can clarify.
Nothing.
No, my lord.
Because the ownership is on the private side. In Assam, my lord, it's government land here.
Our land holdings are based on my lord customary practice. It depends on different tribes, man. So one of them is under provisions under section 88. My lord, that is allotment of government land.
Other than this 9, section 9,
Madam.
the lands mentioned in section 9,
Yes.
government has no right
No.
over other lands.
No. That's why, my lord, we will see, in fact, in the whole state, where it is district headquarters, administrative headquarters, circle headquarters, are usually donated by the people.
Okay.
Now, of course, it has to be acquired. Earlier, it was basically donation.
Okay. What is the issue here?
The issue is, my lord, there was some dispute with the private respondent, my lord. I was issued a land possession certificate by the deputy commissioner. The deputy.
Let us go by one.
Yes, my lord. Your lordship may kindly have page 38. This is a land possession certificate issued to one Joram Appa. He is the husband of the respondent number 4, who is the complainant.
Appa.
Yes. Now divorced. They are having
Joram
some.
Appa.
Yes.
Is petition number 2?
Yes. Yes.
Petition number 2.
Yes.
Below is in possession of Joram Appa.
Yes.
And the said area is free from.
Respondent number 4 is the ex-wife of Joram Appa.
Report of ESC is communicated by censor as well as NOC, given by DFO. So this 1 to 1.8 square meter.
Yes. And my lord will kindly note that my lord will kindly note it does not reflect any provision under which it has been issued.
That by that office memorandum.
Yes. No, I'm pointing this out because there was some confusion in the departments that the LPCs are issued under this act and rules. That's why. So in the subsequent LPCs, your lordships will find they refer to Rule 143.
143 of which one? This one?
Yes. Issue of certificate. 43 and 44 has to be read together, man.
There is revenue payable.
Yes. But this certificate can issue.
Because I have seen the act, revenue is payable.
Yes.
By landholder. Whether it is collected is a different matter. But
No, my lord.
payable.
No, that will be only in respect of this government land. Supposing government, supposing Naharlagan, my lord, this has been gifted by the people of this area. So there are government lands that are allotted to private individuals also. Their revenue has to be paid.
See section 13 of this act.
13, my lord.
All lands
Yes.
to whatever purpose applied are liable to payment of land revenue to the government.
Yes.
Government may exempt any land. I have some doubt. All lands are, land revenue is to be paid. If we see the entire act, this act, land revenue is to be paid. Whether it is collected or not collected, that is a different issue.
There's some confusion in the act.
You are not
itself.
paying, the people are not paying, that is a different issue. To get the benefit, whatever benefit you have, the roads and all, you have to pay land revenue, I don't think. Anyway,
But.
That is why 143 also, the revenue payable.
Yes. So, and my lord, it has to be read with 144. The 144 will come again to 88.6. 88.6 talks about government.
Let us have the facts first
My lord.
before going
Yes.
into the.
So this was, my lord, issued in favor of the petitioner number 2.
Hmm.
Then my lord will kindly have page 58.
No, what is this next?
This is a mortgage, but it's not. my lord,
39.
Yes, I mean.
You mortgaged.
Yes. In fact,
Dora
I'm
Mappa,
extremely sorry, my lord.
mortgage.
The documents are, my lord, not in sequence, so I will
Uh-huh.
take your lordship.
No, I go serially normally. That is why.
Hmm.
I go serially
Yes.
from annexer to annexer.
Yes. This is not even relevant, my lord.
Why it is not relevant?
The issue, my lord, starts
Let
from
us have the
annexer.
documents, then we'll pick up.
My lord.
Then what is this? Page 58.
58, my lord, there was a domestic violence case between the respondent number 4 and the petitioner number 2, wherein this order came to be passed at page 59.
PG.
4 lines from the top. Hence, it is hereby directed that the respondents, namely Jora Mappa or any of the relatives of the respondent husband, are directed to refrain from doing any act of domestic violence against the complainant and her son, and will not alienate the private plot of land situated at Lekhi village, that is the LPC land, my lord, without obtaining permission from this court till the present case is pending before this court. So, taking this, my lord, my LPC was ultimately cancelled, my lord. This is an order, my lord, will kindly note, this is domestic violence case 06 of 15.
Alienate the private plot of land.
Yes.
Likhi village without obtaining permission. Okay.
Yes.
What is this, page 60?
This is the deed of gift. That is, in fact, after the order. Because the petitioner number was not aware of these things, my lord. This is a gift deed, my lord, executed by the petitioner number 2 in favor of the
But petitioner number 1,
Yes.
is he aware?
Yeah, 2, yes. 2 is aware, not 1, my lord.
2 is aware.
Yes, 2 is aware.
He was the donor.
Yes.
So apparently he is alienating.
Yes, yes.
Okay.
No, that we are admitting. I am on the jurisdiction of the secretary.
Okay, we'll. No, but facts are to be
Yes,
clear also
yes,
at the same
yes.
time.
That is how it was done. It was, gift deed was executed in my favor, petition number 1.
Oh, no, that is how petition number 1 has come into picture.
Yes.
Okay.
Then your lordship will have page 69, annexure 5. Land possession certificate was issued in my petition number 1's favor.
Wow.
Here your lordship will find, see Rule 143 AP Land Settlement Act, Rules 2012. After the gift deed I applied, and the land possession certificate was issued in my favor.
It looks like 143
My
is
lord.
a standalone provision.
My lord, it has to be read with, my lord, the rights of landowners, my lord. The rights of landowners, my lord, comes here, my lord,
Because
under.
it is no reference otherwise. There is nothing related to Rule 144.
142.
144. 143 is a standalone provision.
142.
May grant a certificate in respect of each holding of a landowner certifying the nature of his title.
My lord will kindly,
There is 144. Where is the mention?
this comes under, my lord, the chapter right of landowners. It has to be read in the, it is there in the act also. Yes. My lord will kindly have it from,
He
my
has to
lord.
be owner.
Yes.
Plus he has to be in possession. That is
Yes.
what the.
That is the what the,
indicates.
yes,
He certifies.
yes.
Now you have put this petition number 1, petition number 2 has put the petition number 1 in possession.
Yes.
And that has been certified by
Yes.
Deputy Commissioner.
Yes. My lord,
Okay.
in the act, my lord, right of landowners comes from section 88. So this part 12 has to be read with this, my lord. Section 88 and its other sections of the act.
At one time you were saying this is not applicable, this act is not applicable.
And to point out that just to point out that LPCs are not issued under this act.
88.
Yes, rights of landowners. This all pertains to government land. madam. And how it is done. In fact, not only 143, it has to be read from 142 onwards.
This 143 has no head or tail.
Yes.
It looks like a standalone provision. It has no reference to any rule 88, nothing.
Yes, but if your lordship reads as a whole from 142 onwards, it is the title is rights of landowners.
You'd be better knowing than me. Okay.
And if you have the act also, it is titled rights of
Then what
landowners.
happens? Let us see the facts.
Yes. Then, my lord, this land possession certificate was issued in my favor. Petitioner number one's favor.
You are holding a brief for both the petitioner or one only?
Both actually.
Because you are saying my, and for petition number one.
Then your lordship will kindly have annexure 6.
Yes.
This is the ultimately the petition number 2 and the respondent number 4.
Dissolution of marriage.
Yes. I'm pointing this out only for one purpose.
Dissolution of marriage. Then yes.
At page 78.
Yes, 78. Who is the respondent? Petition number 2.
Yes.
He did not intend to contest the suit. So it is assumed that all the facts stated by the petitioner is admitted. Petition. No evidence.
Yes.
No evidence. No testimony.
No.
Huh?
Maybe, my lord, they wanted to be separated, my lord. That's why.
No. This is a judicial court, I think.
Yes.
On admission, but.
On admission. No, even if. Now we have to see how the courts are functioning.
Yes,
That's
yes, my lord.
It is not
Yes.
that only we'll decide this. Simply that respondent did not intend to contest the suit, so it is assumed. And that all the facts stated by the petitioner is admitted by the
Respondent.
respondent. So decree.
Yes.
Decree. Erusiveness. And the prayer. Divorce order. Okay.
My lord, if your lordship kindly at page 78.
Divorced.
Yes. With this order, the case is disposed of with liberty given to the petitioner to file another suit claiming of any property from the respondent. Then, my lord, this is the, my lord, complaint to the Deputy Commissioner for cancellation of the petitioner number one's land possession certificate.
What is the ground?
Primary ground is that the judicial magistrate, while passing that order in the domestic violence case, has restrained the alienation of the land at Lekki village. At page,
That is an interim order. What is the
yes,
final?
in fact, it has been modified. Final, I don't
Huh?
know, final.
It's pending, my lord.
Oh, still pending.
Right.
And this interim order is operating.
Interim order, my lord, in my understanding, has been modified, my lord, now. There have been subsequent orders.
If nothing is brought, we have to assume that this is continuing. Where is
No.
the reference?
At page 92,
No, in the complaint.
complaint, my lord.
Page 79.
At page 81,
Okay.
I'm sorry, my lord.
1 minute.
I'm sorry,
One
80,
minute.
80.
1 minute, 1 minute. Deed of agreement between so and so. What is this? Another agreement, deed of agreement,
Which one, my lord?
page 79. First para.
79.
Huh?
79 is a complaint, my lord.
No. 79. Complaint. There is reference to a deed of agreement. Zoram Yakar Tiki. What is the name of the private respondent?
My lord, this agreement was between the parties, between the petitioner number 2 and the
Huh.
respondent. My lord, there was a village man, it's called Miel over here, my lord, wherein, my lord, we have brought in we have not brought the agreement, but we have mentioned in our statements in our affidavit in opposition that that the petitioner number 2 was directed by the customary court that he would not engage in other illicit affairs. And if he does so, the land would transfer to the private respondent and or the son. That they have also mentioned in their petition, and it also finds mention in the divorce judgment panel at page 76. Starts from page 75, my lord. Para 8.
So apparently the deed of gift is in violation of the interim order.
Yes. Yes.
Apparently.
Mm.
Because till that time it was not. But giving by way of gift
Yes.
is alienation.
Yes, yes.
Okay.
My issue is, my lord, whether the deputy commissioner
Come to
refused
that.
to.
We have not
Yes,
reached
yes,
that.
yes, right.
We have not reached that.
Yes. So this is the complaint.
Then why WPC and all? What is this?
Because
Many rounds.
this was not considered by the deputy commissioner.
Take it
So the
up. There is a
respondent
private
number
respondent.
4. Yes.
Private respondent.
Yes, yes. He approaches honorable
What is
court.
proposed to dispose
Deputy commissioner to
dispose of a cancellation of LPC.
Yes.
Which is dispose of application for cancellation position 2014-2023. What is that? Do that petition number 1 or what?
2410 is the, my lord, complaint at page 79. At page 79, the complaint.
Okay.
Thereafter, page 86. The deputy commissioner, my lord, heard the parties, but refused to cancel the land position certificate.
Someone to appear. Tekiyaka, Likhanap, Zoramappa. Likhanap is petition number 1.
My lord.
She was not in the picture.
The land position certificate was issued to the petitioner number 1 subsequently.
But she entered after the interim order of the court.
Yes.
Your DB case is still pending.
Yes.
Huh?
Yes.
Divorce in 2018, I don't know how it is.
If the relationship is snapped.
Yeah.
In the year 2018. What is say, there are few situations. In DV, one is residential order, and so and so different kind of orders, maintenance orders, this thing, that order. In divorce proceeding, it is a judicial court. So there is question of alimony is always there, right? So 2018, the relationship was snapped by way of a decree, rightly or wrongly. You have not preferred any appeal, and your allegation was assumed to be true. Right. So since 2018, you are proceeding with DV case. So is there any effect legally with a divorce being granted in 2018? Have you examined DV Act?
My lord, on that, the DV proceedings will continue even after divorce. So the violence took place. So therefore, even after divorce, the proceedings can continue.
Let us see what is the practicality, domestic violence. What is the practicality?
Well, there's another aspect. If my learned friend would
No,
continue.
I'm not gone into it because so many things are mixed up here.
One fact, my
LPC,
lord.
divorce,
My lord.
DV, and whatnot.
Another fact which should add to the confusion, my lord, is that this land belonged to my cousin. This was gifted to the son-in-law. This belonged to my family, this particular land. My cousin. My cousin gifted it to him.
Gifted it to him,
Initially.
but as on the date of marriage or date of DV, institution of DV,
My lord.
he was holding the LPC.
He was holding the LPC. That is there.
Protection of the
Protection of
DV Act.
from domestic violence. Protection of women starts from P.
Petition is petition to cancel the license. Damage in violation of the order. One.
2005.
Yes, thereafter what happened? Deputy Commissioner.
Deputy Commissioner.
He did not interfere.
He did not interfere.
Then,
my lord, they filed an appeal, it seems, my lord, under section 83 of the Arunachal Pradesh Land Settlements and Records Act 2000. At page 89. I don't have a copy of the appeal, but the order reflects, yes.
83.
Yes.
This act.
Yes.
You have
83.
shown.
Yes,
83.
83. Save as order was expressly provided, an appeal shall lie from every original order passed under this act. If such an order is passed by an officer subordinate to deputy commissioner, if such order is passed by the deputy commissioner to the government represented by the courtsar secretary. Now, the deputy commissioner refusing to entertain, my lord, the cancellation of LPC was not the proceedings under this act.
All they have come into picture. When private respondent of 4 submitted a complaint before deputy commission.
Yes.
And when it was not taken up for consideration for some time,
Yes.
he approached the High Court.
Yes.
High Court, without going into the merits and without issuing notice to these petitioners, dispose of the representation, dispose of the petition with a direction to consider and dispose of the complaint filed by the respondent number 4.
Yes.
And at the time of hearing, these 2 petitioners should also be afforded a hearing. Then Deputy Commission disposed of the order, considered and disposed of. Then appeal was preferred. Then disagreeing with the order of the Deputy Commissioner, he said that restraining order, on the restraining order of the judicial magistrate, the Deputy Commissioner did not make any observation. Now, at any point of time, the respondent of 4 approached the judicial magistrate or not?
No.
To enforce the order?
No. No, I don't.
No.
No. No, madam.
No.
No.
Then what business they have with regard to enforcing the order? The judicial magistrate court, if finds that that court has the power to take evidence, record evidence, finds that whether that court has the power to enforce or not under this act,
My lord.
to enforce its own order. consider and dispose of. It is not positive direction. It has to be on merit. It has to be on its merit. Deputy Commissioner finding that the order is of judicial magistrate.
Yes.
So he did not touch it. Let it be like that. I don't have to do anything to meddle into that. It is an order of the judicial magistrate. Now, under this, whether that court has the power to enforce or not. Yes, Mr. Counsel.
I'm sorry, man, I didn't bring the domestic violence.
If
Check out. For now.
Don't.
Section 31, madam.
31.
Through protection officer. Through protection officer.
This is penalty.
Penalty.
Hmm. 27(2). Any order made under this act shall be enforceable throughout India.
Sir.
27(2). Jurisdiction clause.
Yes.
And this order under 18E, court can prohibit alienating any assets and order can be passed ex parte as well as by way of interim order.
Yes. Yes.
And that is enforceable.
Enforceable.
Right.
But the procedure, madam.
The procedure is laid down in CPC, CRPC, all are there. So this kind of an order can be passed under 18.
The protection order.
Don't alienate.
Yes.
Right? This is appears to be valid. Secondly, it can be passed ex parte. It can be passed by way of an interim order. And it is enforceable. Plus breach, then penalty also by imprisonment. So instead of going to the deputy commissioner for a complaint, that he is violating, why did not you go to the DB court? Poking here and there instead of the main destination.
Lordship had another query
Uh-huh.
about after divorce, whether the aggrieved person, but not the 2A of the Domestic Violence Act. It defines aggrieved person as a person who is or has been.
Huh. Two
A, my lord.
A.
Aggrieved, definition of aggrieved person.
It could be.
My-
Rule says breach of protection order.
Yes, rules.
Any aggrieved person may report a breach of protection order or interim protection order to probation officer. To the concerned magistrate
My-
for appropriate orders.
In
Rule 15(3).
my lord, that could have been done.
So
Right.
the question of jurisdiction, because your whole case is based on alienation of the property mentioned in the LPC.
Right.
And the direction is that don't alienate. So it is clear that the aggrieved person may, if she so desires, make a complaint of breach of protection order or interim protection directly to the magistrate or the police if she so chooses.
But that is there, my lord. Along with that,
So far as filing of complaint, disposal of the writ petition, and the order of the district commissioner was okay. Assumption of jurisdiction on the pretext that there is no justification provided with regard to restraining order passed by the learned Court of Judicial Magistrate First Class while transferring the LPC in the name of so and so. In my considered opinion, the Deputy Commissioner failed to understand the restraining order for maintaining status quo. In respect to it is not him to maintain status quo. It is for the magistrate to enforce his order. That looks like beyond jurisdiction.
but not one aspect, the magistrate himself cannot cancel the LPC. So for cancellation of the LPC, he had approached the Deputy Commissioner.
No.
Ma'am.
What is to be, what the statute provides, when a procedure is provided in the statute, that procedure must be followed and none else. Magistrate thereafter can direct the Deputy Commissioner, you cancel the LPC, you cancel this, cancel that, cancel that. But without going through, if you take a bypass, which are available to avoid Tezpur, right? That, I'll not visit Tezpur, I'll go straightway to Deputy Commissioner. No. That appears to be not a permissible route. Yes, any other remedy is available. Yes, he violated, and that DV is still pending.
It is still pending.
As you said. Yes, Mr. State Council.
Malot,
So many things.
yes, Malot, I would only submit on whether the.
He cannot sit over.
Yes, Malot.
Whatever be the appellate authority.
Yes, Malot.
He cannot sit over an interim order passed by a court. That jurisdiction has not been vested.
Yes, Malot. That, therefore, we have not filed.
Deputy Commissioner, he said hands-off approach, whatever he said. But he entered into it.
Yes, Malot. Malot, I would only submit on the aspect whether the secretary of the land management department had the authority or had the appellate power.
We are not going into that. We are that to enforce an order.
Yes, my lord.
It is to be the DV court itself.
Yes, my lord.
No third party.
Yes.
But basic allegation and complaint of the respondent number 4 that a cancellation order that he had transferred it to petition number 1, petition number 2. So you cancel it, meaning there was violation.
Yes.
That violation has to be reported to the magistrate. Magistrate will take the course of help of police that take it over possession, then direct the deputy commissioner, don't cancel this. I think that is not the.
My lord, that's why our stand is clear, my lord. In this, for enforcement of the the magistrate's order under the DV case, he doesn't have the jurisdiction, nor as an appellate authority, he had the jurisdiction.
Any direction by the magistrate, yes.
Yes.
But without direction, he will interpret the order.
Yes, my lord.
Only court, that court or a higher court
Yes, my lord.
would have the jurisdiction to interpret the order
Yes, my lord.
or to vacate,
Here,
modify, or implement whatever.
Under the Land Record Settlement Act also, the secretary will not have the power insofar as it concerns with private lands for issuance of LPC.
With reference to so and so. After having gone to the content of the same, this court has wrongly presumed the jurisdiction of this office as the appellate authority as part of provisions of Assam So and so Act, OP Act 2000 and passed consequential order dated 11/3/2024 in appeal case number 1 of 2024. Yes, Mr. Nair, what do you have to say?
My lord, on this, my lord, I feel this is not.
We are not into it. We are not going into it. I am not very
My lord, just on this, just to clarify myself. my lord.
confident about the AP land, Arunachal Pradesh land. Had it been Assam land, yes, I could have passed the order
Right.
now and here, but will not dealt into it.
My lord,
But without going into that aspect,
my
you,
lord,
I'll give the option to you.
if that observation is there,
I'll give the option that as on date is, if the DV case is pending,
my lord, with that observation,
then it is it is for the petitioner, respondent number 4 to approach the jurisdiction concerned magistrate who is in session of the matter.
yes,
Because he has the power under this to execute his own order, enforce his own order. I think that is the only issue. Right?
But just for just our clarification, because this is a gray area, man.
Oh, will not enter into gray area. For gray area, I have to come here repeatedly.
Of course.
Is it not?
My lord.
So we'll put it, we'll dictate the order day after tomorrow in the court. I have understood the case. Put it on Wednesday. We'll take up at after 2. Nam kira likhi kabo. Mr.
Deepangin.
Panking. Petitioners. Mr. Rotor.
Yes, my lord.
And
Or-
Rotor, right?
And Ratan.
Additional Advocate General, Arunachal Pradesh, 1 to 4.
1 to 3.
1 to 3. PD. Nair. Nair Council, along with Mr. T. Pro. For the no 5. List the key. The key as Pathak. Para hearing. I'll dictate them. Nothing to submit.
But if my lord permits, my lord, could my friend be there on Wednesday?
Sure. But that is that liberty would be reserved to the respondent number 4 to take appropriate steps, if so aggrieved.
My lord, with that observation.
With that observation, but this order is to be set aside for lacking jurisdiction.
But that aspect, my lord,
No, that aspect is that had it been the magistrate,
Yes, on the domestic violence,
we are not into the act.
on the AP Act,
We'll go travel through DVA.
DVA. Yes, ma'am.
Right?
Yes, ma'am. Yes, ma'am.
This, who is the landowner, who is this, who is that, we are not going into that. Are not required.
Madam, if it's confined to that, then no. Otherwise it will open a Pandora's box.
Item number
Without
34.
knowing, you should not put your hand in the bees behind, right?
Deeply.
Item number 34.
Mr. Soikia, possible.
Yeah. My lord, may I pray that my lord, the matter will be taken up, fixed on 3rd of the December, my lord.
Try to put some more cases. Can it be some other day? You are available 5th of?
5th, my lord.
5th?
5th is Friday, Lordship.
Huh?
5th is, I think, Friday.
Next Monday.
Okay.
Or it may be on 4th, Lordship.
Huh?
On 4th.
4th?
My lord.
4th of? Matters are fixed. How many matters are fixed?
You can fix on port.
Okay.
For
Our Swakia petitioner, Mr.
S. Tapin, Lordship.
Learned government advocate,
Senior government.
senior government advocate for the state respondents are present as sought for and agreed to by the Learned Council for the party, released the case on 4/12. Regarding records,
on the
can be examined only after that, pay parity.
My lord.
That is all.